In just a moment. In a moment.
The Rules Committee will come to order. We are taking up 3 measures this morning. We will begin with consideration of H.R. 51, the Washington, D.C. Admission Act. This bill is about doing what's right, period. D.C. residents have been taxed without representation for centuries. They pay more per capita in federal income taxes than any state in the country, and more federal income tax than 22 states combined. And they have defended our nation in every war. This step isn't a radical or partisan concept. It is time to give Washington, D.C. residents, over 705,000 of them, the full voting representation and the control over local matters that they rightfully deserve. I want to thank especially Congresswoman Eleanor Holmes Norton for her leadership here. We are closer than we have ever been to finally making Washington, D.C. our nation's 51st state. And we simply wouldn't be at this point if it were not for her tireless advocacy on behalf of her constituents. Next, we will consider H.R. 1333, the No Ban Act, and H.R. 1573, the Access to Counsel Act. The immigration policies of the last administration were harmful, hateful, and counter to everything America should stand for. I'm glad that President Biden has made a clean break and even rescinded xenophobic travel bans on day one. We need to make sure that no future president ever again has a blank check to discriminate against people based on their religion or national origin, and that no individuals at our ports of entry are again denied legal counsel or advice. These bills will ensure that we don't repeat the mistakes of the past and that we have an immigration policy that lives up to our values. Having said that, let me now turn to our ranking member, Mr. Cole, for any remarks he wishes to make.
Thank you very much, Mr. Chairman. Today's hearing covers 3 different items. The first 2 I'll discuss are coming up from the Judiciary Committee, H.R. 1333 and H.R. 1573. Both bills will be familiar to our committee since we considered versions of these during the 116th Congress. H.R. 1333, which the majority is calling the No Ban Act, would completely gut the president's longstanding powers under the Immigration and Nationality Act to make determinations about who can enter the country and under what circumstances. If enacted, H.R. 1333 would curtail the president's ability to suspend entry to a class of foreign aliens if national security or public safety requires. It would also bury the president under extensive and superfluous notification and consultation requirements that would eliminate the president's ability to move quickly to confront threats to our nation. H.R. 1573, the Access to Counsel Act, would provide a right of counsel to individuals being held in detention at border crossings or in secondary inspection proceedings. Guaranteeing access to a lawyer in non-criminal proceedings raises a number of questions, including who would pay for such a lawyer. The bill goes even further to guarantee access to an, quote, interested party, which could even be a co-conspirator in potentially criminal activity, such as illicit drug trafficking, which is unfortunately all too common in border crossings. If enacted, the Access to Counsel Act would constitute an astonishingly broad expansion of the right to counsel for non-citizens and would make quick secondary screening procedures a thing of the past. Indeed, the likely end result would be a much slower process for anyone undergoing secondary screening while attempting to enter the United States. I do believe many reforms are needed in our nation's immigration policy. Unfortunately, and evidenced by the party line vote, both in the committee and on the floor of the House of last Congress, this legislation is unworkable as written. The legislation before us today brings us one step closer to the progressive dream of open borders. But make no mistake, If this dream were to become a reality, the United States would become a more dangerous place. The simple fact of the matter is there's a crisis on our border. After denying the gravity of the situation for far too long, even President Biden finally admitted over the weekend that the border is in crisis. Now it is time for my Democratic colleagues to do the same, change course, and work with Republicans to secure the border. Border agents took more than 172,000 people into custody in March alone. The Border Patrol is making arrests at a pace not seen in 2 decades, and nothing is being done to stop it. And the problem is not limited to just people completely overwhelming our border agents. The open border is allowing illegal and dangerous drugs to come into the country to then be distributed into all our communities. Fentanyl, a deadly drug more potent than morphine, is mainly trafficked through our southern border, and seizures are up over 200% from this same time last year. If the majority succeeds in limiting any president's authority in the ways that they are attempting to today, it will become that much harder to secure the border and that much harder to ensure that those seeking to enter the United States have been appropriately screened. The loser in the end will be the American people, who will rightly lose confidence that the government is doing all it can to protect them. The third item today is H.R. 51, the DC Admission Act. Like the other 2 measures, this one was also previously considered by the committee last Congress. Unfortunately, it too is deeply misguided. While I understand the majority's intention of attempting to ensure that residents of the District of Columbia receive full representation in their national government, the bill is flawed and, even more concerning, unconstitutional. It ignores the Constitution, ignores the practical and legal problems associated with turning the seat of the federal government into its own state, and ignores the reality on the ground. It runs contrary to the intention of the founders and to our constitutional structure, and it ignores other plausible solutions that do not conflict with the Constitution. I look forward to hearing from our witnesses today, particularly regarding alternative proposals to address these issues put forward by Republicans. I'm disappointed that each of these pieces of legislation is just as partisan as in the last Congress. I believe that we had substantive debate and discussion on the flaws of these bills, some of which could have been fixed through more precise drafting. Unfortunately, all our articulated and shared concerns were ignored, and we were faced once again with legislation that had no Republican input, no incorporated Republican amendments, and once again will receive little, if any, Republican support on the House floor. Once again, the majority is choosing to legislate rather than govern. As such, I propose all of these measures. I oppose all of these measures, and I yield back, Mr. Chairman. Thank you very much.
I thank the gentleman, and let me just state for the record that all these bills that we're considering today went through regular order in committee. So I point that out for the record. I am now happy to welcome our witnesses to provide testimony in H.R. 51, the Washington, D.C. Admission Act. Congresswoman Norton and Ranking Member Comer, we are delighted that you are here. Without objection, any written materials you submit to rules.documents@mail.house.gov before the conclusion of this hearing will be entered into the record. I'm now happy to recognize the gentlewoman from Washington, D.C., Congresswoman Eleanor Holmes Norton.
Thank you, Mr. Chairman. Chairman McGovern, Ranking Member Cole, and members of the committee. I'm speaking for the Committee on Oversight and Reform, as well as for myself, in strong support of H.R. 51, the Washington, D.C. Admission Act. This bill would admit the state of Washington, D.C. into the Union and reduce the size of the federal district. Last year, the House passed H.R. 51, the first time in history a chamber had passed the D.C. statehood bill. This year, H.R. 51 has 216 co-sponsors, with the Senate version of the bill, S51, sponsored by Senator Tom Carper, has a record 44 co-sponsors. We have never been closer to statehood. Under H.R. 51, the state of Washington, D.C. would consist of 66 of the 68 square miles of the present-day federal district. Congress would retain plenary authority over the reduced federal district, which would be 2 square miles and consist of the Washington that people associate with the nation's capital, including the U.S. Capitol Complex, the White House, Supreme Court, the principal federal monuments, and the National Mall. Congress has both the moral obligation and the constitutional authority to pass H.R. 51, The country was founded on the principle of no taxation without representation and consent of the governed, but DC residents are taxed without representation, and the United States is the only democratic country that denies voting representation in the national legislature to the residents of its capital. H.R. 51 complies with the Constitution, including the admissions clause, the district clause, and the 23rd Amendment. The admissions clause gives Congress the authority to admit new states, which it has previously done 37 times. The only limitation on Congress's authority to admit new states is that it cannot create a new state from an existing state without the existing state's consent. The state of Washington, D.C. would be created from land ceded by the federal government, not an existing state. The district clause gives Congress plenary authority over the federal district and establishes a maximum size of the federal district, 100 square miles. It does not establish a minimum size or location of the federal district. Congress reduced the size of the federal district by 30% in 1846. The 23rd Amendment, which allows the federal district to participate in the Electoral College, also does not establish a minimum size or a location of the federal district. While the Constitution does not establish any prerequisites for new states, Congress generally has considered three elements in admission decisions: population and resources, support for statehood, and commitment to democracy. DC meets all three. DC's population is larger than that of two states, and the state of Washington, D.C. would be one of 7 states with a population under 1 million. D.C. pays more federal taxes per capita than any state and pays more federal taxes than 21 states. D.C. has a gross domestic product larger than 17 states. D.C.'s bond rating is higher than the rating of 32 states. In 2016, 86% of D.C. residents voted for statehood. D.C. residents have been petitioning for voting representation in Congress and local autonomy for 220 years. As American citizens, D.C. residents are entitled to equal citizenship, but they have also earned it. They have fought in every war, including the war that led to the creation of the nation itself, the Revolutionary War. DC's service members have helped secure voting rights for people throughout the world, yet have always been denied the same rights when they return home. My own family has lived in DC since my great-grandfather, Richard Holmes, as a slave, walked away from a plantation in Virginia and made his way to DC almost 200 years ago. Richard Holmes made it as far as DC, a walk to freedom, but not to equal citizenship so far for our family. Congress must no longer exclude DC residents from the democratic process, forcing them to watch from the sidelines as Congress votes on laws that affect the nation, or votes even on laws enacted by the duly elected DC government. Democracy requires much more. DC residents demand much more. DC residents deserve full voting representation in the Senate and House and complete control over their local affairs. They deserve statehood. The residents can continue, Congress can continue to exercise autocratic authority over the 712,000 American citizens who live in our nation's capital, treating them, in the words of Frederick Douglass, the inspiration for the name of a new state, as aliens, not citizens, but subjects. Or Congress can live up to the nation's promise and ideals, end taxation without representation, and pass H.R. 51. Mr. Chairman, I want to close by thanking both of you and Committee on Oversight and Reform Chair Carolyn Maloney for your leadership on DC statehood. Thank you, sir.
Thank you very much. I will now yield to Ranking Member Comer.
Well, thank you, Mr. Chairman, and appreciate the opportunity to be in front of rules again. With all due respect to your opening statement, I slightly, or rather strongly disagree. H.R. 51 is about one thing, and that's creating 2 new Democrat seats in the U.S. Senate to push forward a radical agenda that's been rejected by the American people. Now, if you don't believe me, then listen to what our friend and colleague, Jamie Raskin, recently told the Washington Post. He said, and I quote, "But there's a national political logic for DC statehood too, because the Senate has become the principal obstacle to social progress across a whole range of issues," unquote. And I think that pretty much sums up the purpose for HR 51. Now, this is all inside Beltway maneuvering. For years, Americans have firmly rejected DC statehood, specifically 1960 and 1993, most recently. There are numerous problems with HR 51. Mainly, it's flatly unconstitutional. Every Justice Department, from President Kennedy's to President Obama's, has declared this initiative unconstitutional. Robert F. Kennedy said granting DC statehood without a constitutional amendment was inconceivable. Robert F. Kennedy also said granting DC statehood would produce an absurdity. But not only did Robert F. Kennedy say that, so did our friend and colleague, Jamie Raskin. Now, during last week's business meeting, Mr. Raskin acknowledged that passing HR 51 without repealing the 23rd Amendment would create a result that would just be ridiculous, in his words. It would be absurd. He noted the 23rd Amendment, quote, absolutely does need to be repealed. He just wants that to happen after DC becomes a state. And the whole point, the Constitution is the foundational document upon which all the laws of our country rest. Congress cannot simply dismiss it with the stroke of a pen and subject to political whim. And that's what HR 51 attempts to do. This bill is an unconstitutional power grab by Democrats, and I would urge my colleagues to oppose it. And I yield back.
Thank you very much. Let me just say at the beginning, at least the way I view this, this is not a partisan exercise. This is about giving over 700,000 people representation. And I went over, and Eleanor Holmes Norton went over the taxes that the people in this in Washington, D.C. pay. Also the tremendous sacrifice that the people in Washington have made in times of war. So that is my motivation. So I don't want my motivation to be mischaracterized. Just one final thing, for the record, I'm a member of the Democratic Party. And so I don't know what the Democrat Party is, but I'm a member of the Democratic Party. And, you know, at a time when many of us are trying to restore some civility around here, I just point out that it would be nice if we were called what our real name is. But
Well, I apologize, Mr. Chairman, if the word Democrat was offensive. I apologize.
yeah, no, that's not what our party. I'm a member of the Democratic Party. But anyway,
Okay, all right.
I have no questions. I strongly support this, and for the reasons I stated in my opening statement, I yield to Mr. Cole.
Thank you very much, Mr. Chairman. Mr. Comer, does the District of Columbia receive any special financial benefits from the federal government that would not continue if DC were granted statehood?
Absolutely, that's a great question. There are numerous unique benefits that
Are you muted?
That's a great question. There are numerous benefits that Washington, D.C. receives. I'll list a few of them here. In the late 1990s, the federal government took over the pension liability for many of D.C.'s teachers, firefighters, and other public employees. That amounted to nearly $5 billion. I wish Kentucky would be in a lot better shape if the federal government took over their poorly funded pension liability system. But D.C.'s entire judicial branch is paid by the federal government. That amounts to roughly $600 million a year, and it's completely off of D.C.'s books. D.C.'s entire prisoner population, and we all know what big of an impact that is on the other 50 states, the prisoner population. That's somewhere between 6,000 and 8,000 people here in Washington, is housed within the Federal Bureau of Prisons and paid for by American taxpayers. Now, that's also completely off DC's books, and that amounts to about $200 to $300 million a year. DC receives tens of millions of dollars per year so that school children can attend higher performing schools in the city instead of their neighborhood school. And so that college students can attend state schools in any of the other 50 states and pay highly reduced tuition. HR 51 allows all of these things unique to DC to continue indefinitely. At some point they would stop. We just don't know when, and that's one of the big questions that the Oversight Committee raised.
Mr. Comer, did your committee's legislative hearing on HR 51, did the mayor provide any specific details as to how the district would compensate for a significant reduction in funding?
She did not, and she was asked numerous times. We actually sent a letter, the Oversight Committee did, to the mayor asking her for this information 2 weeks ago, and she never responded, which is surprising with this being such a big issue for her and the city of Washington, D.C. Very disappointing that she didn't respond. We also sent a letter to the district's chief financial officer asking for the same information. Now, he did respond, but said simply it would be taken care of during the normal budget process. That's a heck of a gap to take care of during the normal budget process, and no details were provided. Now, I'll say this, HR 51 provides for all of the services and special benefits I listed earlier to continue indefinitely until DC is ready to take them over from the federal government. That means the American taxpayers will continue to funnel billions of dollars to Washington, D.C., even after it became a state. And this could potentially occur for 100 years. There's no time restriction in this legislation. But once it finally does end, D.C. has provided no information on how to pay for it.
So in your view, there would be significant financial problems for the District of Columbia should it become a state?
Well, one of the reasons why it failed in 1993, and ironically, Steny Hoyer voted against it, being a member of Congress from a neighboring state who had a lot of his constituents that worked in Washington, D.C., is because they feared that Washington, D.C. would put a commuter tax on. So, but we've never gotten confirmation from that, from the mayor. There's been no specifics on how Washington, D.C. will be able to function without the massive subsidies that Congress is appropriating the capital city now.
If D.C. would experience...
Mr. Chairman, the district is asking for no special, the district is not asking for anything further from the federal government. Once it goes through the transition period, there will be some transition assistance just to get the district through that period, as there has been for every state. The district fully recognizes it will have to take over each and every function and the expenses that go along with statehood. And I might add that there are so many people moving into the District of Columbia that our budget is fueled by the number of people who want to live in the District of Columbia and who pay taxes in the District of Columbia. We're asking for nothing from the Congress that has not been given to every state, and that is simply transition assistance that will allow us to become a state. Thank you, Mr. Chairman.
Thank you. Is there any specific timeline on transition expenses spelled out in the legislation?
No.
And there's never been transition assistance timeline spelled out in legislation for any state that has been admitted to the union.
Well, that's a fair point, but this one is not any state. It's a very unique situation. Mr. Comer, would there be national security implications if there were financial failure of the District of Columbia?
Absolutely. I mean, let's not forget about what happened in the 1990s. DC was so severely mismanaged that a Republican-led Congress had to come in and rescue it. Congress created a control board to oversee DC's finances. 2 years later, it passed the Revitalization Act, taking billions of dollars of expenses off the DC books completely. DC officials like to talk about their 23 consecutive years of clean audits. Well, it started only because Congress came in and had to take it over in the first place. Under HR 51, the entire federal district, including the Capitol and White House, would be surrounded by the new state of DC. It would be entirely dependent upon DC for physical security. So if DC's finances aren't in order, there's no telling how a foreign entity may try to exploit that.
Okay, let me ask you a different question. Under HR 51, what percentage of the land, the proposed District of Columbia state, is land originally ceded by Maryland?
What now? I'm sorry.
What percentage of the new state, were it to come to be, is land originally ceded by Maryland to the
It's 100%.
100%? Okay, and the last time the Rules Committee considered this legislation, we're told that Congress had two choices. But in actuality, Congress has a number of options available to provide representation for the District of Columbia. Isn't that correct?
That's correct.
And can you describe a couple of the other options that might both provide representation but be more constitutionally sustainable and perhaps more fiscally viable?
Well, there were a couple of other options. One is what you mentioned. You could cede the Maryland part back to Maryland, the Virginia part back to Virginia. I believe that's correct. The other is you could pair Washington, D.C. with Puerto Rico so they could both enter as states into the Union at the same time. Of course, that would expand the size of the Senate by 4 votes. And Chuck Schumer's already said he does not support statehood for Puerto Rico, probably because their delegate to Congress is a Republican. Nevertheless, Mr. Raskin's offer is the only mention by any Democrat of an alternative proposal instead of ramming HR 51 down the throats of American people who have firmly rejected DC statehood. There's been discussions of making the delegate a voting member on the full House floor. Right now, the delegate, of course, is a voting member in the House Oversight Committee and a very active member of the House Oversight Committee. There are a lot of alternative options that I think could have been discussed, but the Democrats had no time or will to sit down with Republicans to talk about alternatives. Because in 1960, when this was voted on originally, the alternative was to give Washington, D.C. 3 electoral college votes. That's what the 23rd Amendment did. So it gives them 3 electoral college votes. And ironically, when this bill is passed, the Washington, D.C. area will have 6 electoral college votes because the 23rd Amendment has to be repealed, or they're going to have 3 electoral college votes for Washington, the new state of Washington, D.C., plus 3 for what will remain as the Capitol Enclave, and the only resident of the Capitol Enclave will be the first family. So they would get 3 electoral college votes. We brought this up in committee, and they said, well, they'll take care of it. I don't share their confidence or enthusiasm of taking care of that after the bill passes and DC would become a state.
Thank you very much. Thank you, Mr. Chairman. I'll yield back.
Yeah, thank you very much. I just want to remind people that in 2016, I think 86% of the residents of DC voted for statehood. And I don't know, maybe it's just me, but I have a real tough time believing that somehow somebody from Kentucky or even somebody from Massachusetts should micromanage what the people of Washington, D.C. want. I don't want anybody from Kentucky telling me in Massachusetts how to run my state or any place else in the country for that matter. And again, I think it comes down to a simple question. I mean, do we respect the rights of the people in D.C. to be able to have a voice in the Congress and to be able to move away from taxation without representation or not? I mean, that's what this debate is about. I yield to Ms. Torres.
Thank you, Mr. Chairman. I just want to add that taxation without representation is the reason why I'm supportive of this bill. And with that, Mr. Chairman, I yield back.
I now yield to Dr. Burgess.
Thank you, Mr. Chairman, and Mr. Gomer, your discussion that you were just involved in with Mr. Cole on the 23rd Amendment, the number of electoral votes that would then be possessed by this new state being proportionally greater than any other state would have. Is there a remedy for that problem?
Well, what you should do is amend the Constitution first and then pass the legislation. This is doing it in the reverse order. And I believe that it will not make it through the courts. This will be litigated for years. This will create uncertainty. And at a time when we don't want to continue to have election uncertainty, I think this is a bad precedent. If they're serious about passing this bill, they should amend the Constitution first.
Yeah, it's an interesting point. Is there any kind of precedent or parallel where one constitutional amendment has to be repealed before a new constitutional amendment could happen?
Well, I'm not the constitutional expert in the conference. That would probably be Mac Johnson, but I will say this, the last time we repealed an amendment, it was prohibition, and we had to pass an amendment to the Constitution to repeal the amendment that created prohibition. So the same thing would happen here, you would think, with HR 23 or with Amendment 23. So this is, we've been down this road before.
So let me ask you a question. You said this is likely to be litigated. As this is litigated, is that after two senators are seated or before?
That's a great question. It looks to me like it'll be after the two senators are seated. When the courts eventually kick this out, there will be countless cases of bills that pass by 1 or 2 votes with the 2 new Democrat Senate seats, whether they're legal or not. And I just think there's going to be create a lot of havoc on our Constitution, on our democracy. And if they're serious about it, they'll take care of the constitutional problem first, which is the 23rd Amendment.
It would seem like the logical order. Now, I remember our former colleague, when I first got here, Roscoe Bartlett from Maryland, was a member of the House, and he used to talk about a phenomenon that he described as retrocession, where that part of the district that had been ceded by Maryland, you would subtract out the federal enclave, I guess, and that part where people actually lived would be taken back into the state of Maryland. And they would have senators, the 2 Maryland senators, and obviously because of the size of the district, they would be entitled to proportional representation, just as every other state is. Is that something that you explored in the committee?
No, we filed different amendments. Did we have an amendment that did that? I don't know if we had an amendment that did that or not, but every Republican amendment failed. But I think that's a great idea. If their issue is really that they want 2 U.S. senators, then that's the perfect solution to the problem.
And again, I don't know my history as well as I should, but there is precedent for that as well. There's a portion of Virginia that was ceded for the federal district eventually went back to Virginia, did it not? I
believe that's right. Yes, that's correct.
So again, we have actually traveled that road before. Well, I appreciate all of the thought that you put into this. Sure, there's part of this that does seem just absolutely political, and I get it, and I get why it would be so, but at the same time, that doesn't make it right, and we do have an obligation to try to get it right. So I certainly appreciate your efforts, and no, Mr. McGovern, I wouldn't want to make decisions for the state of Massachusetts. I think we should leave things that are states up to the states, but things that are properly placed into the Constitution for a reason, we should respect those as well. And I'll just say one last thing. As I read through the bill, and I tried to spatially follow the descriptions as they were given, but it's pretty darn complicated. Do we have a physical picture of what this federal enclave would look like?
Yes, we do. I can,
Is
Show
there,
that
is
to
it
you.
possible to, that we put that into the record at some point? I
What-
mean,
yes.
personally, I'd love to see it because I
Yes.
couldn't follow what the descriptive text that was
Oops.
given in the bill, and you've got one there. All right.
Yeah.
Well, very
Yeah.
good. And again,
All right.
Mr. Chairman, I would request that that be part of the record on this hearing, and I'll yield back my time.
Without objection. And I would just say to Dr. Burgess, I'm very glad that you don't want to make decisions for Massachusetts, and that's one thing we can agree on. I would also just point out, because we're hearing these constitutional arguments, we didn't amend the Constitution before admitting Alaska as a state or Hawaii. So I'm just, there's all these new standards here when it comes to the District of Columbia. I don't really get.
Mr. Chairman, if you'll yield for a moment, did Alaska have 3 electoral votes prior to its admission as a state?
That's good.
No.
And just further, as that you've recognized me for additional comments, I'd just say back home in Texas, you know, Massachusetts wouldn't even be a good county. So we're all good where we are. And I'll yield back.
Yeah, you can say that again. I will now yield to Mr. Perlmutter.
Thanks, Mr. Chair. I support this legislation. Ms. Norton has been intrepid in bringing it and continuing to fight for it because it's the right thing to do, and I appreciate that. I'd say to my friend, Mr. Comer, the only uncertainty about the last election was stuff that was created out of whole cloth. There was nothing there to begin with. And I don't think that the uncertainty that the gentleman suggests will exist when we make Washington, D.C. a state. And with that, I'm going to yield back.
Thank you very much. Mr. Rushenthaler.
Thanks, Mr. Chairman. I appreciate it. We gotta look at the facts here. We gotta look at the 2 overarching theories, and there's really 2. One is that
The gentleman just
this requires a
because I think either your microphone's not on or somebody else's microphone is on in the room and you're echoing. So, okay. All right. Thank you.
Mr. Chairman. We got to figure it out. Thanks, Mr. Chairman, for yielding. I appreciate it. So there's 2 overarching ideas. One is that this is a constitutional possibility and this can do it. I would say that that process and that argument is not correct, and I'll do my best to explain that. And also that this is just a good idea on the substance. I would actually argue it's a bad idea on the substance. And if you look at it, Article 1, Section 8, Clause 17 specifically says the district will be a 10 square mile federal district. And there's really good reasons for that. During the Articles of Confederation, the capital was in my home state of Pennsylvania, and there was a mutiny. And the governor of Pennsylvania and the mayor of Philadelphia did nothing to stop it. So the founders never again wanted to have Congress beholden to a local municipality, whether it be a state or whether it be a city government, for protection. So we knew we needed to have a federal district in terms of some square mileage, not just some federal enclave. Additionally, there's a lot of good evidence that the framers, even some modern commentators, feel that if we did have a state that housed the capital, that we would create super delegates. And by that, we would have senators and we would have members of the House that would have just powerful influence. They wouldn't have to go home and travel to their district. They'd be able to stay and just embed in the committee process. They'd be basically super senators and super members. And it's just not our founding fathers that said that. My esteemed colleague from Maryland has said, I could read the quote from my colleague, Jamie Raskin. The representatives from the new state will likely live minutes from their offices, will theoretically devote more time to institutional and committee politics and less to constant travel back and forth across the country, increasing their importance and influence on the Capitol Hill. It's a strange day when my colleague Jamie Raskin and I agree, but he actually wrote this in an article. So again, we also have an issue of taxation. I know we've talked about DC and how they're going to raise revenue. There's only really one way DC would raise revenue, because they can't tax federal property. They would have to have a tax on commuters. So you would have to tax individuals coming in from Virginia, Maryland, West Virginia with a tax for the privilege of working in DC, and or you would have to have excessive tolling, where if you're coming into DC, those roads would be tolled, and that's how you'd raise revenue. Either one of those options is problematic. Let's just look at the latter with tolling. You would, in essence, you would thwart a lot of travel to DC, the ability to petition your government that's called for in the Constitution, because you would just have excessive taxes in commuting or in coming to DC. Where for a commuter tax, you would do the exact opposite of what you're proposing to do. That is, you're taxing people that have no representation in the district. So your solution to the problem that you've contrived is actually to create the same exact problem, only this time it's people from West Virginia, Virginia, Maryland, and elsewhere who would ultimately pay that tax. And I'm not the only one that said that. Former DC delegate, I believe it's Delegate Norton's predecessor, said when you talk about DC statehood, this, and I'm quoting, this would be in direct defiance of the prescriptions of the founding fathers, end quote. So again, for all those reasons, bringing in DC as a state is simply a bad idea, and it's not an idea that was supported by the founding fathers, and it was certainly not supported by recent members of the Democratic Party. Now let's just talk about the procedure with the Constitution. There's no way you can argue that this is constitutional without a constitutional amendment. For one, you just had Dr. Burgess elicit from Ranking Member Comer that DC already has 3 electoral votes. DC is different than other states that have come into the Union. The Constitution is clear that those states come in through a vote. They can either come in through territory, like, for example, Missouri came in because it was a territory from a state splitting off from another state, West Virginia, or you could have an independent nation coming in. Hawaii and Texas come to mind. That's not the case here. We already have a federal district that's called for that already has representation. Delegate Norton, you're here. I don't mean to be cheeky with this, but you're actually here testifying. You have votes other than when we're actually on final passage. We also have other forms of representation. So to say that, like the Electoral College, again, the members have a say in the electoral vote. So to say that DC has not been considered or somehow like a new state coming in from a territory is not accurate. But you don't have to take my word for that. You have DOJ, you have Departments of Justice going back to JFK, RFK, and Carter, the Carter administration, saying that. I could read some of the quotes, but RFK, when he was the Attorney General, said, Congress likely did not have the authority under Article 1, Section 8, Clause 17 to shrink the federal district to essentially the same size being discussed today. Basically, he was arguing that we shouldn't even had retrocession back when we ceded territory, or DC ceded territory to Virginia. Also, he said, arguments that a federal district constituting the seat of government is a permanent part of our constitutional system is substantially strengthened by the adoption of the 23rd Amendment. And if you go back and you look at it, you can even say that not only is retrocession now, when we're talking about the land controlled by, that was originally Maryland, but the land in Virginia was also arguably unconstitutional. Congress itself passed a bill in, I believe, 1867, saying that that was an unconstitutional retrocession. The Senate Judiciary never took it up. And when it was challenged at the Supreme Court, it was kicked out due to lack of standing. So we can argue about this current retrocession, but the last retrocession, time did not actually cure that. So with that being said, those are my arguments, but I want to come to some testimony. Delegate Norton, given the fact that RFK Jr., the Carter administration, even the Obama administration prior, in the early days and prior to Eric Holder, in his opinion, said this was unconstitutional, how do you now justify that you think this is constitutional?
Well, I certainly acknowledge that legal opinion has been divided on HR 51, and that no court has ever ruled on DC statehood, though we believe the bill is constitutional. Committee has received testimony and statements for the record from legal experts that HR 51 is constitutional. I cite to you Viet Den. He is a former Georgetown University professor. He was Assistant Attorney General in the George W. Bush administration, and he said courts would likely decline to adjudicate any constitutional challenge to the act, and in all events would likely hold that the act is constitutional, end quote. The Justice Department would almost certainly defend the statute if there is any constitutional challenge.
Okay, so just for the record, though, you then disagree with the Carter administration DOJ. You disagree with the Kennedy DOJ, specifically Attorney General RFK, and in the JFK administration, and originally the Obama administration. I mean, just for the record, you disagree with all those DOJ opinions.
I think you should depend upon the Biden DOJ in making a decision by this committee.
Well, you can certainly depend on them. I will not be depending on the Biden DOJ opinion. Precedent would say otherwise. But let's just talk about no taxation without representation, which is your argument. You talked about the taxes coming into DC, but given the fact that you would have massive amounts of your territory being federal land that you couldn't tax as a state, how would you raise the revenue that would be necessary just to function as a state?
The district, as I speak, is raising so much revenue that it does not have any need for more revenue because so many people are moving into DC. The way we're raising revenue is because, for example,
let me just reclaim my time because that's patently false. Actually, are you aware that between February and July of 2020, over 15,000 people actually moved out of the District of Columbia? Are you aware of that?
I can only tell you that if you look at the latest census, and that we believe it will come out soon, you will see more people moving into the District of Columbia than moving out.
Well, Ms. Norton, you can certainly conjecture that, but I have the facts in front of me. You had 15,000 people move out just in 2020. And if you think people were moving in, you only had 400 people moving into the district. So the district is actually shrinking, not only in actual population, it's also shrinking in relative size. When this was first debated back in the 60s and 70s, there was something like 9 states, or DC had the population in excess of something like 9 states. Now, because the district is small in territory and the other states have grown in population, there's only 2 states, I believe, that are actually larger. But to go back to my original argument on the substance, the framers always had this in mind. They always knew that DC would be a metropolis. In fact, when George Washington was laying out the city planning for the city of DC, they used Paris as an example because Paris, of course, was the premier city of the West. That size of Paris at the time was 800,000 people. The framers designed this city to accommodate 800,000 people. Even today, we're not at that number. We only have 700,000 people here. So to say that somehow the framers didn't intend for the city to grow, mature into a metropolis is just factually inaccurate, as well as the assertion that DC is somehow growing in population. It's just statistically just improbable. And I want to pull up some tax information. If you'll just indulge me a minute to pull it up, because I want to make sure I have the facts right. But you were talking about how DC contributes so much in the federal government. Are you aware, though, that per capita, DC actually receives the highest amount from the federal government than any other state?
Could I correct you, please? Could I correct you on that? The federal government provides only 23%. Remember that figure, 23% of DC government revenue. Nationally, the federal government provides 32% of state government revenue. So the federal government isn't supporting the District of Columbia.
Well, so the facts actually say otherwise because I have them right here. So DC
I have mine too.
Receive the highest I'll share these facts with you, but you can't refute the math. DC residents also receive the highest per capita expenditure from the federal government. That comes out to over $73,000 per person. And if you think that sounds extreme, it is, because the next state that receives that much is Virginia. It's $16,000. You're talking about a distant second, $73,000 per person in expenditure per capita compared to Virginia at 16. Of course,
you're talking about federal contracts and wages. You're not talking because the federal government is located here. That's irrelevant. to the residents of the
Well,
District
again,
of Columbia.
simply the only way you can possibly raise the revenue would be a commuter tax, which again would be the exact opposite of what you're purporting, which would be actual taxation without representation. Or you would have to have tolling taxes where people would have to pay, all the tour buses come in, would have to pay tolling, which would again cut off access to the Capitol, which is called for in the Constitution. But let's just get back to the minimum size established by the district. There's been talk that we should have this retrocession, but your predecessor, actually not your predecessor, I'm sorry, I misspoke. The former mayor of DC, Walter Washington, actually considered this, and he flatly rejected the idea. He said that if you did have a retrospection, you had the enclaves that you're purporting to have, where you would basically just carve out a federal campus. And I quote, "I would have problems with statehood in terms of exacting from it some enclaves or little enclaves all around the city. Ultimately, it seems to me that would erode the very fabric of the city itself and the viability of the city." So again, the former mayor of DC wouldn't even go this far. Additionally, your predecessor, Fauntleroy, said that doing this would also be in direct defiance of the prescriptions of the founding fathers. So with that, without Ms. Norton, I'm going to yield to Ranking Member Comer if you have anything to add.
All right, thank you very much for yielding. There are things that I wanted to make. Chairman McGovern mentioned something that I agree with. You know, he didn't want Kentucky people telling Massachusetts people what to do, and I'm sure Massachusetts people don't want to tell Kentucky people what to do, but you all but you federalize that and took that right away if that becomes law, that they can't show a voter ID. So you have passed several bills this session, which tells Kentucky people what to do against what Kentuckians want in their state's rights. The other thing, and I don't want to get into an election uncertainty thing, but I just wanted to correct the record. When you said there was no election uncertainty, we had 2 House races in New York and Iowa that weren't settled for months. And even you'll remember just a few weeks ago, you tried to undo the election in Iowa because you said there was uncertainty. But that kind of withered away when there was so much outcry by the public over that. And just in the last 2 presidential elections, there were numerous polls that showed scenarios where there would be 269, 269. When Hillary Clinton ran against Donald Trump, and when Joe Biden ran against Donald Trump, there were many polls that came out that showed scenarios where there could be 269, 269. If you have 3 extra electoral college votes hanging out there, that would create a lot of election uncertainty, because I think we would all agree America's pretty divided. You look at the Senate's 50-50. If you all lose 2 votes in the House today, the vote fails because it's a tie. So America is pretty evenly divided as you can look at Congress. So I just wanted to correct the record, and I appreciate everything that's been said. Again, this is a Democrat political power grab, and it's unconstitutional. And with that, I yield back.
Thank you, Ranking Member. And Ms. Norton, I want to go back to the 23rd Amendment issue, because I don't think that was clarified. I asked you the question, and it's on me. I didn't give you the chance to answer. So how would you reconcile the 23rd Amendment issue? Because if the bill as you purport it passes, you would have a state in the territory of DC, which would have, of course, 3 electoral votes. Then you would have the so-called federal enclave, which would have 3 electoral votes. And again, I don't mean to be cheeky, but you would give Joe Biden, Hunter Biden, each 1 electoral vote, which would totally skew the electoral system, because you would only have the residents of the White House actually living in the district. How do you reconcile that?
Well, the bill would repeal the enabling statute of the 23rd Amendment. And the 23rd Amendment itself does not
Ms. Norton,
need
could
to.
you yield back? Could you yield back? But that's not how the Constitution works. And
You didn't give me the
of an
opportunity
amendment.
to respond.
But I think there's some
Excuse me,
confusion.
Ms.
No,
Rachel.
but, Ms. Norton, let me.
I appreciate you trying to throw all this stuff out, I think for the sake of whatever, but if you're gonna.
No, I'm actually making a valid legal argument.
If you're gonna raise these issues and ask Ms. Norton to respond, give her a chance to respond.
I will, but I was correcting her because that's not how the Constitution works. That's not how you repeal an amendment.
It's not
But
your
I'll
job
yield.
and my job.
You didn't give me the
Out of respect
opportunity
for
to.
you, I will yield.
Yeah,
Mr. Chairman,
well,
I
you
respect
certainly are
you,
showing
and
no
you-
respect for me right now when you don't even give me the opportunity to finish my response, sir. So could I finish? I was at the beginning of my response.
I'm yielding to you, Ms.
Well,
Norton.
you're not yielding to me. You asked me a question. You asked me a question, I have the right to answer. If you would just shut up until I do answer. I began by saying the 23rd Amendment would repeal the enabling statute. Before I could get to the rest of it, you interrupted me. What we would expect is that the Congress and the states would quickly repeal the 23rd Amendment to prevent the reduced federal district from participating in the Electoral College. And if I may add, even if the 23rd Amendment were not repealed, Congress may have the discretion as to how it awards electoral. Provides, and I'm quoting, that the federal district shall appoint electors in such manner as the Congress may direct. So there's ample ways to make sure that the district doesn't have 3 extra electoral votes.
No, thanks, Ms. Norton. I do want to clarify the record. If you felt like I disrespect, I'm trying to
I sure
disrespect you
I
at all.
sure did.
Well, it's a shame you feel that way. That was not the intent. The intent, though, is the question was when you were talking about legislatively repealing the 23rd Amendment. With all due respect, that's just not how amendments work. If that's how it worked, you would never have a 21st Amendment because you could have legislatively repealed the 18th Amendment. But it took the 21st Amendment to constitutional amendment to repeal a constitutional amendment. That's the way it works. You cannot do it legislatively. Yeah, maybe I was sick the day they taught law at law school, but that was my understanding. Additionally, you cited Viet Din as actually your only support on this. I'm not sure if you're aware, but Din did not support DC statehood. He just simply opined that the constitutionality of previous legislation opposing statehood. In fact, he has emphasized that there are significant concerns that counsel against admitting DC as a state, and that's his own quote. Additionally, Din noted that DC does not have the traditional qualities that the founders required for states, stating DC, and I quote him, would hardly present the sort of economic, cultural, and geographically diversity of the traditional Madisonian democracy, end quote, because, and picking up back the quote again, it would consist entirely of one city whose existence and prosperity are tied to the federal government, end quote. Further, Din, and again, I remind you that Din is the only expert you've cited to for this authority, and he doesn't agree with you. Din also argued that DC would have, quote unquote, an outsized influence in the Senate, given its exceptionally small geographic size and relatively low population, unquote. Moreover, it would undoubtedly retain the culture of a national city. It would likely enjoy the advantages of geographic proximity to the federal government. That sounds a lot like the imperial city talked about in the Federalist Papers, and it sounds a lot like my colleague Raskin's 1990 law review article in Catholic University's Law Review. So, and then finally, Din also testified that without repealing the 23rd Amendment, which grants the district 3 electoral votes, and I quote, to be sure, it makes little policy sense to grant the smaller remaining district's residents outsized influence on the presidential election. Given that the president and the first family would be among those few residents, it would pose a particularly precarious situation and advantage to presidential incumbents. So again, you quoted Vin Din, and those were his exact quotes. I want to say this though. The 23rd Amendment clearly is problematic. Would you support me if I offered an amendment today to delay DC statehood until the 23rd Amendment is repealed? Because if it's as easy as you're saying, you should join me in the amendment so we can make sure that it's a condition precedent on DC statehood. I yield
Now,
back.
that would be for the purpose of blocking statehood. I would not support it, and you know full well that's the only reason you would support it. The 23rd Amendment will be the fastest amendment ever repealed, ever passed, the fastest constitutional amendment ever passed, and you know that. Nobody wants to have 3 electoral votes, so that's a nonsense question.
Hey, if that's the case, then there's no problem with my amendment, because if it's going to be that easy to repeal the 23rd Amendment, let's make a condition precedent on the final DC statehood.
There can be no condition on a state either gets admitted or not. It cannot be conditionally admitted.
All right, that's your reading. I'll end with this. We started with a bunch of talk how this isn't political. I wholeheartly disagree with this. This is nothing more than a mere power grab by the Democratic Party to try to stack the Senate, to try to get 2 more votes, to end the filibuster, to pack the Supreme Court, to get rid of the Byrd rule. This is just an attempt to dismantle our system of government. If you don't believe me, I will quote my colleague from Maryland once again. In March 20th, 2021, my colleague from Maryland said, quote, "There's a national political logic for it," meaning DC statehood, "because the Senate has become the principal obstacle to social progress across a whole range of issues," end quote. There it is right there. The quiet part said out loud. This is nothing more than a political power grab. I yield back. Thank you, Mr. Chairman.
The gentleman yields back. I would like to ask unanimous consent to insert in the record, in case there's any question, the statement of administration policy, which basically says that the Biden administration calls on Congress to provide for a swift and orderly transition to statehood for the people of Washington, D.C. So if anybody's wondering where the administration is on this, that's that. I should also point out that no other democratic country has a capital whose citizens lack equal voting rights. And so I point that out. And I got to say, you know what? The gentleman just talked about this being a political debate. Well, the tone of that exchange was very, very political. And unfortunately, if people have legitimate disagreements, but anyway, I yield to the gentleman from Maryland, Mr. Redskin.
Mr. Chairman, thank you very much. I must confess that it's a bit surreal to hear my various law review articles quoted back at me in a way completely opposite to their meaning, to destroy what it was I was actually saying. And I will, before my brief time eclipses, I will answer several of the things that were raised. But I do want to go to Congresswoman Norton, because I think this is such an essential moment of a breakthrough in public understanding about the injustice that is being experienced right now by 712,000 tax-paying, draftable American citizens who live in our nation's capital. And I want to try to pierce through that fog of propaganda that we just heard to get to the reality of the situation and the clarity of constitutional understanding. But let's start with this. I did want to thank Congresswoman Norton, both for her excellent leadership on this issue, but also I want to thank her constituents for not storming our Capitol, not breaking our windows, not beating up our police officers and smashing people over the head, not causing the deaths of many people, even though they actually have a serious democratic grievance. Their voting rates are being violated every day. And yet, far from coming and laying siege to the Capitol based on some trumped up fantasy, which is what we just experienced on January 6th, her constituents came to our aid. The Metropolitan Police Department came and defended the Capitol against the insurrectionists and marauders who would have toppled the 2020 presidential election. That's right. In other words, hundreds of police officers, maybe thousands of police officers and people who live and work in DC came to aid the defense of the democracy, which they're excluded from on an equal level, which demonstrates their absolute passionate devotion to American values, unlike the people that they had to come and guard us from. Now, should we interpret the failure of your constituents, Congresswoman Norton, to come and storm the Capitol because they had a political grievance, should we interpret that failure to mean that they actually don't want statehood? Are they not serious about it, Congresswoman Norton?
Congressman Raskin, the residents have been trying for 220 years through peaceful means to get equality in their own country. They have never stormed the barricades, and I do not expect them to.
Well, did you have a vote about this? Was there a referendum recently on statehood?
There was a referendum, and 86% of the residents of the District of Columbia voted for statehood.
So 86% of the people voted for statehood, which is more than a number of residents in the states that all of us represent on the Rules Committee voted. In a bunch of states, it was less than that who actually voted for statehood. But you're saying there's an overwhelming consensus within DC that people want to achieve political equality within the system of American federalism. They want political self-government as a state, and they want equal representation in the US Senate and in the US House. Now, we've added 37 states in that way. Have any states been admitted, Congresswoman Norton, and I ask you because you are a fellow professor of law, have any states of those 37, the nearly 3/4 of the states that have been admitted to the Union, have any of them been admitted by way of a constitutional amendment?
All 37 states have been admitted by majority vote. We're asking for the same, we're asking for the very same.
So all have been admitted by Congress under Article 4, Section 3, under Congress's admission power, the power that Congress has to admit states. And that is also determined to be a political question by the Supreme Court. In other words, there has never been a case where a statehood admission has been struck down by a court. Isn't that correct?
That is correct. And in fact, the courts would likely regard this as a so-called political question, not one for the courts.
Well, but wait a second. There have been lots of constitutional arguments advanced against other states when they were coming in, including states represented by people on this committee. Take Mr. Burgess's beloved home state of Texas. It was said that was absolutely unconstitutional because Texas used to be its own country. It was an independent republic, and nothing in the Constitution allowed Congress to admit a foreign country as a state. Was that struck down by the court? Was it ever even considered by a court?
It was not even considered by a court. Let's put it that way.
Okay, well, what about Oklahoma? It was said Oklahoma was far too poor to be a state, far poorer than the people you represent. It was said there was no way they could support themselves. Was that struck down in court? Or was that left as a political question for Congress to decide?
It's a political question for Congress to decide. And of course, states have the opportunity for a transition period to get into the union when they feel that they are ready.
Well, some people are saying that you can't be admitted because the land that's still part of Washington, D.C. used to be part of Maryland, right? Well, Kentucky, whose distinguished representative is your counterpart here today, that used to be part of Virginia. Did that stop Kentucky from becoming a state?
Well, it certainly didn't stop Kentucky from becoming a state. And if I may speak about your own state, Mr. Raskin, that state gave the land for the district and used the words that were used by the state of Maryland, forever ceded and relinquished.
Well, in fact, I've got it right here. The Maryland General Assembly said that all that part of said territory called Columbia, which lies within the limits of this state and the same, is hereby acknowledged to be forever ceded and relinquished to the Congress and government of the United States in full and absolute right and exclusive jurisdiction, which means in fee simple in property terms. It's up to Congress to do with it as it will. And that becomes a constitutionalized principle because of Article 1, Section 8, Clause 17, which says that the Congress shall exercise exclusive legislation in all cases whatsoever over the land that is to become the seat of government. And it has, that power is so absolute and plenary that it has used that power to modify the boundaries of the district and to cede land back, for example, to Virginia, or to redraw the boundaries in other cases, including back in 1791. So let's come to the 23rd Amendment, which seems to be their main focus and the last ditch argument they're making. Okay, so the 23rd Amendment was adopted in order to advance the political rights of people living in the seat of government so that they could, they would be able to exercise power through voting in a presidential election over the number of electors that they would be entitled to if they were a state, although no more than the smallest state. So there's even a principle of inequality built into the 23rd Amendment, which I think helps to explain a small piece of why people in DC want out of this colonial straitjacket that Congress has put them in. All right, so the 23rd Amendment is out there, and they say, well, they're not exactly saying it's unconstitutional, I don't think. They just say it would be absurd if you had a new state which had electoral college votes, as it would, because of the equal footing doctrine, which says every state has to have equal powers and equal rights. All right. It would be absurd if the new state got to participate in presidential elections and the 23rd Amendment continued to operate with respect to what's left in the federal enclave, which would be the White House, the Capitol, the Supreme Court. There really wouldn't be any people there other than the president and his or her family. And nobody says that that's the purpose of granting statehood to 712,000 disenfranchised Americans. And everybody is saying, we just repeal it. Now you've gone further and just to say, not only will you be the first one to introduce the amendment to repeal the 23rd Amendment, and it will sail through the states, as it would, you're saying, we've got belt and suspenders, okay? We are actually going to deactivate the federal statute that had to be passed in order to organize the Electoral College. Because everybody knows, we just went through this on January 6th, it's the state legislatures which create the voting system, and then it's the legislatures which appoint the electors through the legal system adopted by their state. But nothing happens without the state legislature organizing it. And that's the exact same way the 23rd Amendment operates as well. If you look at the text of the 23rd Amendment, what it says is that the district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct, right? And then again, in section 2, which you quoted before, upon the hopefully not deaf ears of our colleagues, the Congress shall have power to enforce this article by appropriate legislation. Congress adopted a statute to organize the Electoral College, and if I'm reading your bill right, section 223 repeals that section of federal statute. So now they're not only is it going to sail through as a matter of repealing the constitutional amendment, but your statehood admission bill takes care of it right there and repeals the federal statute that organized the Electoral College. So even if the President of the United States or the First Lady or in reverse were, I don't know, fantastical enough, whimsical enough to say we want 3 Electoral College votes for ourselves, they would have no standing because there's no federal statute that they can operate under. Everybody would see it's plainly absurd. In any event, it wouldn't be unconstitutional, so that's not a constitutional obstacle. It just shows it's absurd. It shows the absurdity of the argument they're advancing because everyone knows that this will be repealed immediately. And by the way, on the question of the 18th Amendment prohibition and the repeal of prohibition, the section 1 of the prohibition article banned the import and the traffic in liquor across the country and gave both Congress and the states the power to enforce that prohibition. So that needed to be repealed by constitutional amendment, which of course it was. And this will be repealed by constitutional amendment in due course. There's not a single person in the country. I challenge my colleagues to find one person in the country who would say the 23rd Amendment should remain after. But in any event, Congresswoman Norton, you've taken care of it by repealing by statute the organization of the Electoral College. Now, it has been said that it was invoked by our colleague, Mr. Reschenthaler from Pennsylvania, appropriately enough, that there was a moment at the time after the revolution when the Constitutional Convention was meeting in Philadelphia, and there was a band of disgruntled Revolutionary War soldiers who were basically engaged in some kind of mutiny outside of the Constitutional Convention. And he said, the governor did nothing about it. And that was what helped give resolve to James Madison and the framers to draw up Article 1, Section 8, Clause 17 to make sure Congress would have exclusive power over the operation of Congress itself, the seat of government. So they would not have to depend on the local state for support. And that is historically accurate, what he said. Now, I want to say two things about that. One is that Congress and the federal government will continue to have absolute power over Congress, the White House, the Supreme Court, the so-called National Capital Service area. It will exercise absolute plenary police power jurisdiction to cover it. But the second thing I want to say about it is we need to be doing a much better job of securing that area. We, the federal government, because it was the local community that had to come to our aid. It wasn't the governor or the mayor of DC who did nothing. It was the president of the United States who did nothing, who dragged his feet and refused to call up the National Guard, which is under federal control, ultimately in the District of Columbia, not under local control. It was Donald Trump who did nothing. And some of our colleagues don't even want us to have a bipartisan commission to investigate the events and the causes of that nightmarish insurrection that took place in our building just 3 months ago. Okay, so don't lecture the people of DC about how they're somehow interfering with congressional police power or federal police power to protect the Capitol. They did everything they could to protect the Capitol. That was a problem in the executive branch of government. In any event, don't use that as an excuse to keep people from DC from having their own state and protecting themselves against the recklessness and the negligence of a president like that. All right, now let me just answer a couple final points, and maybe you can help me, Congresswoman Norton. I'd be interested on your thoughts about this. Our colleagues have said from the beginning, and I heard it in the Oversight Committee, I heard it again today, they keep saying, it's political, it's partisan. Okay, well, let's be grown-ups about this. Let's try to think seriously, historically about it. The admission of new states has been the trajectory of political inclusion for people in America. That's how you get to a level of political equality. You get to govern yourself under your own state constitution. And then you get representation in the US Senate and in the House of Representatives. So there's a principle there, which is why we went from 13 states to 50 states. We added 37 states. And that was the Jeffersonian model, that when enough population formed, then we followed the dictates of the Republican Guarantee Clause. We guarantee that the Republican form of government come to the people who live in those states, and they organize themselves under the 9th Amendment of the Constitution. But let's be grown up about it. We also know that it has been a political matter, as our colleagues keep insisting, for most of American history, which is why most states have entered the Union like animals boarding Noah's Ark, in twosies. They come in pairs. That's what the Kansas-Nebraska Act was. That's what the Missouri Compromise was, Missouri and Maine. That's what Kentucky and Vermont were. Hawaii and Alaska came in within a year of each other, again, on basically a partisan deal, although then it was predicted Hawaii would be Republican and Alaska would be Democrat. So look at that. All of you clairvoyants who say that there will never be Republicans elected from the District of Columbia, even though there have been Republican members of your DC Council. But in any event, they've entered in twos. So I'm looking at the situation, and Mr. Reschenthaler took me to task for saying there was a national political logic for doing this, but there is a national political logic for doing this because it's been in the Republican Party platform since World War II that Puerto Rico should be a state. Since World War II, every 4 years, they say the people of Puerto Rico, there are more than 3 million American citizens living in Puerto Rico, should be admitted as a state. As recently as 2016, it would have been in the Republican platform, I think, in 2020, if passed as prologue, if they'd had a platform in 2020, but they decided that Donald Trump himself would be the platform in 2020. But I digress. In any event, it's been in the RNC platform for decades. Meantime, the Democrats have had DC statehood and voting rights and representation in the Democratic platform for decades. So what do you know? Maybe there's the ingredients for some real live bipartisanship, some real negotiation. But all I get from my Republican friends is crickets. I read somewhere, well, they want to raise money in Puerto Rico, but they don't really want to enfranchise the people of Puerto Rico. Really, I don't believe that. Ronald Reagan stood up for Puerto Rican statehood. Gerald Ford stood up for Puerto Rican statehood. The resident commissioner, the delegate from Puerto Rico, is a Republican who's campaigning for statehood. So where are you guys? Tocqueville said in Democracy in America that voting rights and democracy in our country are always either expanding and growing or they're contracting and they're constricting. Well, which is it going to be? Is it going to be a war on voting rights? Are we going to try to keep people from voting through voter suppression tactics? Or are we going to open America up to the trajectory of political, historical, and constitutional development that we've got? And I vote for that. And Congresswoman Norton, I don't know if you have any comment on that. Obviously, you're fighting for your people, and that's got to be your major agenda. But looking at it as a representative from Maryland, one of the 50 states, I say, hey, we've got one party that's been arguing for statehood for these people, one party arguing for statehood for these people. Let's put it together and let's make democracy grow. I don't know if you have any thoughts on that.
Well, and I appreciate that the state of Maryland now, except for its Republican member, does support statehood for the District of Columbia. And when Maryland is raised as the state out of which the district was formed, it seems to me bear repeating that Maryland is supporting all that the Maryland senators and the Maryland delegation are supporting statehood. I should also like to mention that 54% of the American people now support statehood for the District of Columbia, according to a very detailed poll that's just been done. The reason that I think that outcome has occurred is that these hearings at yes markups have led the American people to know what they didn't know about their own capital. They were confused. Some thought the people in the Capitol had the same rights they had. Many did not know, some were against it. Once the kind of exposure that the Rules Committee is now giving statehood, that our hearings, that our votes have given statehood, we now find 54% of the American people support statehood. That was a very detailed poll, and I will predict that when we come up again on Thursday, that number will increase. Americans do not want to live in a nation, the only nation in the world, at least the only democratic nation in the world, that denies equal representation in its legislative body to the residents of its nation's capital. Thank you.
Okay, and thank you, Congresswoman Norton. That's a very powerful statement, and I just want to close by commending again Article 1, Section 8, Clause 17 to our colleagues. It establishes a maximum size for the district, but no minimum size. Obviously, the framers knew how to specify a minimum size if they wanted to, but they didn't do that. And also, I hope my colleagues will note that in giving the power to exercise exclusive legislation in all cases whatsoever, meaning exclusive legislative power over this district, including obviously the power to modify the boundaries of the district, it says, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Well, like authority Congress from the very beginning, the federal government from the very beginning has been able to acquire property in other states, federal forts and dockyards and so on, and also dispose of them and change their boundaries. That is like authority. And I think Mr. Reichenthaler thought that he struck a major blow against Congresswoman Norton by saying that so much of the land in the District of Columbia is owned by the federal government, and that somehow is either a constitutional or policy mark against the new state. 60% of the land in Alaska is owned by the federal government, a lot more than is owned in the District of Columbia. Does that mean you've got to disenfranchise the people of Alaska? I don't think about it. Yeah, I don't think so. And I hope that my colleagues will understand that every specious argument of a constitutional or non-constitutional nature being advanced right now against this new state has been advanced against pretty much every other state that has ever petitioned for admission to the Union. But the overwhelming logic of America is democracy and representation for people on an equal basis. I yield back to you, Mr. Chairman.
Thank you. Ms. Fischbach. You have to unmute. You have to unmute. You see, you're not, hold on. We don't hear you. No, not yet. So you know what? Why don't we go to Mr. Morelli and then we'll come right back to you. See if we can figure out your sound thing. Okay, Mr. Morelli? Is Ms. Scanlon here first? No, okay. Mr. Morelli.
Actually, I have no questions, Mr. Chairman.
Okay, should we try, let's try Ms. Fischbach one more time, see if that's.
Is that better?
Yeah, we got it. Okay, all right.
There
beautiful.
we go. And Mr. Chair, I apologize. Every time I switch formats, something changes and it goes off. So, but thank you, Mr. Chair. And first, I'd like to just say that I agree with and associate myself with the comments made by my Republican colleagues and the questions they've asked. I too have concerns regarding the lack of the time limits, especially because this is a unique situation with the District of Columbia, and that it is left to this new state to determine when the federal government will stop paying the programs that are currently being covered by the federal government. But I want to direct just my question specifically at Representative Comer. Ranking Member Comer, I too have concerns about the bill, about its constitutionality, and this does seem to be, whether the majority party wants to admit it or not, it does seem to be another attempt, a political attempt at packing the courts and like eliminating the filibuster just to add additional Democrat members to the body. And I was just wondering if you would comment potentially on the ramifications of that. And then I'd also like to just give you the opportunity to comment or respond on anything that you've heard so far.
Well, thank you very much. The ramifications are, it's mind-boggling with 2 new Senate seats. I think, I wonder if we would even be having this discussion if Joe Manchin were going along with everything, if he would agree to end the filibuster. And I think this is plan B of the Democrat political power grab. If Joe Manchin's not going to walk the line like the rest of the Democrats in the House and the Senate, then they're going to create 2 new Democrat Senate seats. That's what the purpose of this legislation is. I do not trust that they will just fix those extra 3 electoral college votes after they pass this bill and Washington D.C. becomes a state. If you're going to fix the 3 electoral college votes, then we offered an amendment in committee. We've offered an amendment here in the Rules Committee. Let's just do it now. Let's just do it now. 22 state attorneys general have written a letter strongly opposing this legislation and saying they will challenge it in court if it becomes law. One of those state attorneys general was from West Virginia, where Joe Manchin resides. So it is a huge issue. And just, with respect to what Mr. Mr. Raskin said when he asked about if her constituents, if Miss Norton Holmes' constituents charged the Capitol. I mean, when we came back to Washington this new session, I mean, the whole downtown area was boarded up. I mean, somebody destroyed the, I mean, if it wasn't Miss Norton's constituents, maybe it was Mr. Raskin's constituents. I don't know, but every window was busted out in about a 6-block area. So I don't think that's a good argument. If we get back to the point, it's the constitutionality challenge with this bill can be addressed if we repeal the 23rd Amendment now. And, you know, when you make the argument, when Ms. Norton Holmes makes the argument that Congress will fix it, I apologize, but I don't have confidence that Congress will do anything. I mean, during the campaign, you had the administration, you have members of Congress on the Democrat side say they weren't in favor of packing the Supreme Court. Well, just last week, they filed legislation to add new seats to the Supreme Court. Now they're wanting to make Washington, D.C. a state, to add new seats to the U.S. Senate. They're changing the rules as we go on everything. So it would have huge ramifications. And I just don't think at a time when America is as divided as it is, this is a good answer. You know, we need, we could potentially compromise on some things to make sure that if Washington, D.C. feels like they need more representation in Washington, think about that. Washington, D.C. needs more representation in Washington, then they can become a part of Maryland. I think that's a good compromise. But they were unwilling to compromise because it's about 2 Democrat U.S. Senate seats.
And thank you, Ranking Member. And I appreciate your opposition to the bill, but I also would encourage the majority to reach out and talk to you about some of those compromises that are possible. And with that, Mr. Chair, I yield back. Thank you.
Thank you, Mr. DeSaulnier.
I have nothing to add, Mr. Chairman, other than to thank Representative Norton for
Thank you.
diligence.
Thank you. Ms. Ross.
Thank you, Mr. Chairman. This has been just fascinating. It's especially interesting to me because more than 30 years ago, as a young recent college grad, I moved to DC and worked on the Hill and worked for a nonprofit and joined the League of Women Voters and joined the fight for DC statehood. And now I'm going to get to vote on it. And so I want to just applaud Congresswoman Holmes Norton for all that she has done to represent the state, represent DC, despite the fact that she hasn't been able to cast a vote expressing what the more than 700,000 people in DC would want from the federal government. And this is distressing, not just because more than 700,000 people are not getting their full representation, but these are the people we work with every day. These are the people who make the wheels of this government turn. I submit they may make better representatives because they understand the government more and they understand what having their rights denied to them really means. And we've talked a little bit about taxes that people in DC pay. DC residents pay the highest per capita federal income tax in the United States. They pay more federal income tax than 22 other states combined. And they are subject to taxation without representation. Moreover, in January, the residents of DC saw their city overrun by an extremist mob of insurrectionists who stormed the Capitol. Many Capitol police officers, local law enforcement, and others risked their lives to control the mob. They are DC residents, and they don't even get to have their voices heard on any of the legislative responses to the attack. I'm proud that as a 20-something, I saw this as a crucial issue when I moved to DC. Again, I applaud our colleague, Congresswoman Holmes Norton, for everything that she has done to represent this area. And we now have a chance to enfranchise hundreds of thousands of Americans and make Washington, D.C. the 51st state. I am wholeheartedly in support of this. And with that, Mr. Chairman, I yield back.
I thank you very much for yielding back. I think everybody has asked questions. Let me say to the panel, thank you for being here. This is, to me, this is a very important issue. It's a voting rights issue and it's a civil rights issue. And I look forward to bringing it to the floor. So I thank Ms. Holmes Norton and Mr. Comer, and you are now dismissed. Thank you. We will hear any amendment testimony in HR 51 at the end of our hearing today. Right now, we will go to HR. I want to call up our next panel now to testify on HR 1333, the No Ban Act, and HR 1573, the Access to Counsel Act. Chairperson Lofgren and Subcommittee Ranking Member McClintock, we're delighted that you are here. Without objection, any written materials you submit to rules.documents@mail.house.gov before the conclusion of this hearing will be entered into the record. I now recognize the gentleman from California, Chairperson Lofgren.
Oh, thank you, Mr. Chairman. Today, we take steps towards the enactment of two bills, the National Origin-Based Anti-Discrimination for Non-Immigrants Act, or the No Ban Act, and the Access to Counsel Act. Both bills address issues that should be of concern to all of us, preventing executive overreach and providing access to family or counsel during secondary inspection. The No Ban Act would prevent overreach in the President's authority to suspend the entry of non-citizens into the United States under Section 212F of the Immigration and Nationality Act. As a candidate for president, Donald Trump promised to, quote, ban all Muslims from entering the United States. He suggested, without any evidence, that it would somehow make our country safer. Immediately upon entering office, he tried to deliver on that promise by invoking Section 212F, claiming that the admission of individuals from 7 Muslim majority countries would be detrimental to U.S. interests. In court, the Trump administration claimed the ban was necessary to keep our country safe from terrorists, and yet a bipartisan coalition of former national security officials strongly refuted those claims. In addition to the Muslim ban, President Trump also relied on Section 212F to circumvent clear statutory requirements related to asylum. Section 208 of the INA specifically allows individuals to apply for asylum, quote, whether or not they arrive at a designated point of arrival, unquote. The law could not be clearer, but apparently unhappy with it, President Trump invoked Section 212F to categorically deny asylum to those who cross the border between ports of entry rather than seeking to amend the law by working with Congress. This was an attempt to rewrite our nation's immigration laws in direct violation of the separation of powers. The power to write the law is ours, not the president's. Fortunately, President Biden has revoked the Muslim ban, as well as other executive orders that stretched or exceeded the bounds of Section 212F authority. But H.R. 1333, which realigns Section 212F with its intended purpose, is still necessary. We should take action to prevent any future president from using this authority to usurp legislative power in the future. The Access to Counsel Act was passed last Congress and will ensure that individuals who seek to enter the United States with facially valid travel documents can contact family or counsel if they're held for an extended period for secondary inspection. The bill would simply allow individuals to communicate with counsel, petitioning employers, or individuals and other interested parties if they're subjected to prolonged inspection. The INA provides individuals in removal proceedings the right of representation, I should add, at no expense to the government. However, applicants for admission, specifically those in primary or secondary inspection, are excluded unless they become the focus of a criminal investigation. Due to the complexity of our immigration laws and the fact-intensive nature of questions regarding admissibility, it's not uncommon for some people to languish in secondary inspection for many, many hours. Many individuals subject to inspection report having their phones confiscated and are effectively cut off from communication with the outside world. Access to outside assistance is important to ensure that CBP has a complete understanding of the facts and the law before making a determination on admissibility. That's because serious consequences can result from refused admission, consequences that extend well beyond simply turning around and getting back on a plane. Individuals who are refused admission may be unable to reunite with their families or marry their fiancés. They may be denied the opportunity to work for U.S. employers in need of their expertise, complete their PhD degrees, or continue their groundbreaking medical research. To be clear, the bill does nothing to alter the existing authority of CBP to deny entry. However, it would help ensure that CBP has all the facts while making that decision. These issues have always existed, but they became more obvious and urgent during the last administration. In the aftermath of the first Muslim ban and in January 2020, when dozens of American citizens who were of Iranian descent were held for hours at the Blaine port of entry amid rising tensions between the United States and Iran as an example. Learning from lessons of the past, we should move these pieces of legislation forward today. I thank Representative Chu and Jayapal for introducing these bills, and I urge my colleagues to support them and yield back the balance of my time. Thank you, Mr. Chairman.
Thank you very much. I now yield to Mr. Ranking Member McClintock.
Thank you, Mr. Chairman. The Judiciary Committee's Republicans oppose H.R. 1333 and H.R. 1573, and we request that if over our objections this bill is brought to the floor, it should at least be under an open rule so that members of this body can have the opportunity to amend both bills. These bills were marked up last week without a hearing on either subject during this Congress. The hearing conducted on H.R. 1333 in the last Congress gave short shrift to the implications to public safety and national security of restricting the president's ability to set travel restrictions from countries that pose a danger to our country. It instead focused on the false narrative that President Trump had declared a Muslim travel ban. President Trump invoked this authority against countries that were hotbeds of international terrorism and that were not cooperating with the United States in providing basic information about travelers coming from these countries. It had nothing to do with religion, race, or any of the other complaints we heard from the left, as the Supreme Court ultimately found. In fact, the court found that the fact that some of the countries covered by the proclamation have Muslim majority populations, quote, does not alone support an inference of religious hostility, given that the policy covers just 8% of the world's Muslim population and is limited to countries that were previously designated by Congress or prior administrations as posing national security risks, end quote. Indeed, the restrictions ultimately included North Korea, Chad, Tanzania, Eritrea, Burma, and Venezuela, none of which are Muslim majority countries. When countries cooperated with us to assure that we could adequately vet travelers coming from them, as every other country does, these travel restrictions were lifted. Without this authority, the president would have been powerless to take simple, prudent precautions against terrorists and other undesirables entering the United States. Among other things, this bill requires the president to get the permission of the Secretary of State before invoking this authority, which is constitutionally absurd. The Secretary of State is subordinate to the president. It requires that the order be the least restrictive measure, that is, the weakest measure possible. And it gives anyone who claims any harm the standing to block an order in district court. The president's ability to negotiate and, when necessary, to retaliate against discriminatory actions by other countries depends on having this power at his disposal. And we oppose weakening it on behalf of Republican and Democratic presidents who invoked it in the past, including Barack Obama and recently Joe Biden. Now, the Democrats also ignore the reality of what is happening on our southern border. H.R. 1573 would grind legitimate trade and travel to a halt by providing that virtually anyone referred to a secondary inspection while trying to enter the U.S. at a port of entry can stop the process until they've had the opportunity to consult with an attorney or, for that matter, any other third party. Now, I recently visited the inspection facility at Hidalgo Crossing with a number of other Republican members of the Judiciary Committee. We invited the Democrats, they were too busy. What we saw was a crossing where thousands of cars and trucks pass through the port of entry, and they have to be inspected to protect our country from high volume cartel smuggling. Our agents are experts at spotting suspicious traffic hidden among the high volume of legal crossings without unduly delaying honest commerce and honest crossings. To do this, they waive the suspicious traffic to secondary inspections where they can identify contraband with sophisticated equipment run by experienced officers. This has been of a tremendous inconvenience to the Mexican crime cartels. We saw millions of dollars in methamphetamines and other deadly drugs that have been seized at these secondary inspections. But now imagine what would happen if every smuggler waived to a secondary inspection can stop that process cold by demanding a lawyer or some other third-party consultation. Now, there are 17 million secondary inspections conducted each year at our 328 ports of entry. 17 million. Can you imagine the effect of this bill? Now, remember, the inspection is not a criminal process. The inspection is simply to determine that things brought into the country meet the requirements of law. Only once it's been determined that a crime is involved, then the individual does have the right to counsel. But this bill would stop the secondary inspection cold until a lawyer or other third parties brought into the process. The practical effect would be to rapidly back up traffic until secondary inspections would simply have to be abandoned. If this isn't actually written by the drug cartels, it certainly is entirely in their interest and service. It speaks volumes about the attitude of the Democrats on the security of our border, the safety of our citizens, and the sovereignty of our nation. There is a very simple question presented by both of these bills. Do they make Americans more safe or less safe? Does restricting the president's authority to restrict the entry of aliens who may pose a danger make us more safe or less safe? Does restricting the ability of Border Patrol officers to stop illegal drugs and other contraband from entering our country make us more safe or less safe? The answer ought to be self-evident to anyone with an ounce of common sense. I yield back.
I thank you both for your testimony. I just want to say for the record, I think Ms. McClintock, you said there were no hearings. And the report on both bills, they referred to a hearing on February 25th, February 11th. And the Subcommittee on Immigration and Citizenship held a hearing titled "The U.S. Immigration System, the Need for Bold Reform," where the No Ban Act was discussed. So I just want the record to reflect that accurately. I have no questions. I support both these bills. I'd like to ask unanimous consent to insert in the record the statement of administration policy in support of both these bills. I'm happy to yield to Mr. Cole.
Thank you very much, Mr. Chairman. I appreciate that. Mr. McClintock, I understand you just returned from a trip to the southern border. You referred to it a little bit in your testimony, talked a little bit about the conditions, but could you just give us some insight into what you observed and what you heard while you were there?
Well, I have to tell you, it was the most disturbing tour I've ever taken in the U.S. Congress. What we saw was a country without borders. We're way beyond the discussion over whether this is a border crisis. The question now is whether we have borders at all. I put that question to the president of the Border Patrol Association, and he curtly responded, no, we don't have effective borders. We saw crowding in these facilities beyond imagination. Cubicle after cubicle of all, what I can best describe as cattle pens, packed so densely with children that in some of them you couldn't even see the floor. In one of them, designed for 33 people, they had, I believe it was 527 packed in. They don't test these kids for COVID when they're admitted. They're only tested once they go over to HHS. And in fact, we also visited a HHS facility that had its own COVID wing because of the incubation of this virus in these cubicles, along with conditions of lice and other things that were causing the Border Patrol officers enormous concern. We watched illegal aliens literally walk out of the brush onto a dirt road, line up in Disney-style lines, do a quick interview with Border Patrol officers, and then many of them were actually taken directly from there to transportation hubs. On my flight out of McAllen, Texas for Houston, there were very many of these groups on the flight with all of their instructions of where to go. They're being released in many cases without even a notice to appear. So as a matter of practicality, we have no effective border. And the damage that is doing to the folks who are being encouraged to come here by the statements and, more importantly, the policies of the Biden administration is just tragic. Gallup warns us there are about 42 million people living in Latin America and the Caribbean right now who very much want to come to the United States if they can. And now they can, and now they are. And if that is allowed to continue, that means we're at the beginning of a mass migration, literally of historic proportions. And I don't know of any civilization that has ever survived such a phenomenon.
Yeah, I've heard those kind of descriptions over and over from members that have gone to the border. In your opinion, do either of the pieces of legislation that we're considering here today help deal with the conditions that you describe?
No, in the case of the Office of Field Operations, it conducts the inspections for contraband at our legal points of entry, quite the opposite. It makes their job virtually impossible. Of course, none of these are addressing the principal problem, which occurred when President Biden abandoned the previous administration's Remain in Mexico policy, abandoned construction of the borders, and actually instructed ICE to stop enforcing deportations. As you know, there are about 1.2 million court-ordered deportations right now pending in this country, and ICE arrests have been reported down 70 to 80%. You know, right now, as I said, the southern border is an open invitation to anyone in the world who wants to come here. All they have to do is pay the cartel fee, and they get a free pass into the U.S. And again, we watch them literally being waved into our country. You know, it's ridiculous that the Democrats, who were all too willing to criticize the Trump administration, are now ignoring this worsening disaster on the southern border, simply because the Democrats in the White House. One would think this is a policy that they actually support, and perhaps they do if one listens to the Speaker Pelosi last week, who says that the conditions down there put us on the right path. My God.
Mr. McClintock, HR 1333 makes it virtually impossible for a president, either party, at any time, to exercise his or her lawful authority to temporarily pause certain aliens or classes of aliens from entering the United States. Happen to know why that authority was originally given to the president?
Well, because Congress saw the need for the president to be able to act quickly and efficiently in order to protect our country from foreign nationals. I mean, not have our best interests at heart. This measure hands that authority to the Secretaries of State and Homeland Security so that the president can prevent the entry of aliens only if his own cabinet says it's okay, which of course is completely backwards. The Constitution is pretty clear. The executive powers are vested in a president of the United States. It says nothing about the Secretaries of State or Homeland Security or any other bureaucrat. Their authority flows from him, and the executive authority to him flows from the Constitution of the people. So it completely turns the Constitution on its head. But worse, it requires that that authority be invoked only if it is the least restrictive alternative available. That means only if it is the weakest possible thing that he can do. And at the same time, give standing to anyone who can claim any kind of harm. Let's say a trade association for hotels, for example. If you're reducing the number of people coming into the country, they are harmed. Gives them the ability to go to any district court judge and ask to block that that order. Again, it's a pretty simple question. Does this make our country more safe or less safe?
I think that poses it well. I just one more question. HR 1573, poses very serious legitimate. I spoke at length about that in the last Congress, and I'm pretty disheartened to see the language remain identical to what we've seen before. So were you provided in your trip to the border with any assurance, formal or informal, by the CBP that they would be able to carry out this legislation without diverting critical resources, including those used to interdict a massive amount of illegal drugs and human trafficking, other goods pouring across our border illegally?
No, quite the contrary. The CBP officers that I talked with, every one of them, told me that they were overwhelmed as it is. They're using antiquated facilities. They're suffering manpower shortages. It's typical already there for legal traffic to be backed up for several hours during peak periods in their current condition. Without a massive expansion of facilities and manpower, I think the CBP would be given the Hobson's choice of either curtailing inspections or routinely backing up traffic for hours on end.
So is it fair to say in closing that, so many of the Biden administration measures, I would argue, have made problems worse, certainly not made them better. This legislation will actually, far from helping us solve the problems that you saw, are going to exacerbate the problems. Is that a fair statement?
Well, I think that's a fair and a very accurate statement. And again, the sum total of these policies can be very clearly seen in the numbers. The week of the 2020 election, 100 family units illegally crossed our entire southern border. By the week of the inauguration, that number had increased to 1,100. The week ending March 24th, the number was nearly 14,000. That ought to give you a pretty clear indication of what has been happening in response to this new administration. And it's frightening. And it's going to be felt in every community in our country.
Thank you very much. Thank you, Mr. Chairman. I yield back.
Thank you. And I know the gentleman from Oklahoma shares my concern on this, but one of I just want to say this for the record, because when it comes to talking about immigration, I mean, we tend to talk in these very stark terms, that like everything is very kind of simple in terms of how things are operating down there. And the reality is that we're never going to effectively deal with the migration issue unless we acknowledge the internal strife in the countries that people are fleeing from. In the 1980s, the United States dumped a whole bunch of money into Central America, supporting brutal militaries and corrupt governments. When the wars were over, we walked away. Those wars produced a whole bunch of migrants and refugees, and we walked away. We just left them there. We saw the proliferation of gang activity, corruption, and we see that to this day. And one of the primary reasons why Salvadorans are coming to the border is this incredible crisis of hunger within El Salvador. Not to mention gang violence, and not only that's not just unique to that one country. So we can talk about building walls and tough talk and separating children from their parents and all that other kind of stuff, but I think we got to be honest with ourselves that at the end of the day, unless we take a more holistic approach, we're going to be having this conversation in the same kind of polarized way over and over and over again.
Mr. Chairman, since you're responding to my comments and question, may I respond to yours?
Sure, yeah.
we have a different view here. I don't dispute at all that there's serious problems in Central America. There have been for not years, there have been for decades, maybe centuries, but a long time. I don't agree that we, quote, walked away. I've been to that region many times. American aid has been robust and appropriately so. I have no problem with that. I think that's a good thing. I remember being cheered when a group of us landed in a very remote village in Guatemala, for instance, because of the food assistance the United States was providing to people under very difficult circumstances. I took a great deal of pride in that as an American. I'm sure you would too. And so I don't think we've been disengaged, and that's what the problems are. But and we should continue to be engaged, no question about that. That doesn't mean we open up our southern border willy-nilly. And what's happening down there now is a crisis of unprecedented proportions. I think Representative McClintock is right. And I don't think the measures that have been taken along the border have made things better in Central America. I think they have made them worse on our side of the border. That doesn't mean we should abandon trying to work with governments down there and do what we can, but I don't think it's going to get solved quickly or easily. I think, again, I think the Representative McClintock's descriptions, which I've heard over and over again from other members, and you now are seeing in the media, despite the administration's efforts to make that difficult to do, it suggests to me that we have to think about security on our border too. We have to think about the flow of drugs. We have to think about the flow of human trafficking. These are not all innocent people coming through, although I would suggest the majority are. But that doesn't mean that if the United States has no border control and no effective immigration policy, and we're fairly generous now with over 1 million legal immigrants a year, then I suggest you'll be overrun in that part of the country. So you don't abandon the area, you don't quit helping people, but you do secure the border for the protection of our own citizens, in my view.
Yeah, well, I guess my point was, you compare the level of aid we provided when we were engaged in the wars in Central America, and see and look how our economic assistance package has diminished greatly as a result. Those countries were destroyed, and what we should have done when the wars were over was we should have led an international effort to help those countries rebuild. We did not. And yes, we do provide, USAID provides good support for good programs. But I'm going to tell you, what we are doing is nowhere near what needs to be done to bring some stability to that part of the.
Again, I don't necessarily disagree with you on that. I would support additional resources. But that doesn't mean that you cut back on border security efforts, which I think is Mr. McClintock's point.
Yeah, no, but I watched what happened the last 4 years, and I've been to the border several times during the last 4 years. And I interviewed families who are legitimate refugees who were stuck in Mexico, who were being turned away. I talked to parents whose children were taken away from them. I don't want to, that's to me not the solution either. I'm just simply saying at some point, if we want to get serious about dealing with the issue of migration from Central America, we have to move this discussion to a wider scale to talk about how we help encourage these countries toward a position of stability where they're dealing with some of the internal strife that why people are leaving. If I were a parent and my kid, life was in jeopardy, you bet your life I'd do everything I could to get him or her to safety. If my family was starving, you bet your life I'd do everything I can to try to make sure they had food. So we have to understand that as well. But I don't want to go off onto a tangent, even though I did. But let me now yield to Ms. Torres.
Thank you, Mr. Chairman. And I just want to say that I agree with some of the comments from our ranking member, and I agree with your comments as well. You're absolutely right. 50 years of terrible U.S. Policy in the region, arming strongmen, continuing to support really bad actors. Since coming to Congress, I just want to assure all of you that I have been working with some of you, that are on this panel on a bipartisan, in a bipartisan way to try to address the issues, the root cause of migration. There is no easy way, out of the problems that have been created by these strong men in the region, specifically in the Northern Triangle, for sure. But what I am committed to is ensuring that no hardworking U.S. taxpayer dollars continue to flow to the region that will fall into the hands of these strong men that continue to oppose these very vulnerable populations. And as a result, we continue to see now no longer just adults or family units, but very, very young children traveling north. It is no surprise that the Northern Triangle countries of El Salvador, Guatemala, and Honduras have set the example for the rest of Latin America, that as a leader in any one of these countries, you can sit in your hands and do absolutely nothing while your people flee horrible conditions. And it's okay to throw children over a 14-foot fence that are 3 and 5 years old because you don't care about those children because they actually have a two-caste system in that region. That is a deplorable way to dehumanize these kids. I'm disappointed on how some of my colleagues continue to address the issue of the children at our southern border as a national security problem. I don't think that we should be afraid of these children, and I am very happy that we are no longer simply pushing them back across the Mexican border, where they too often had fallen victims to the drug cartels and really bad actors on the other side. So for the first time in the last 4 years, we're actually protecting children and protecting their humanity from all of these people that want to do them harm and want to take advantage of them. And I hope that, at some point, all of us find and agree that these are little human beings that deserve our support and comforting them while they're fleeing these terrible conditions. I am, concerned, as some of you are, about a secondary checkpoint. Some of these secondary checkpoints include, vehicles that come under question. So I would like our chairwoman, Ms. Zoe, to address the issue or to give us a definition of what we are talking about when we are discussing providing legal representation to some of these groups. Who are we talking about here? And can you give us a little bit more detail on that?
Yes, this bill is actually very narrow and would not apply in that circumstance. It deals only with individuals who are coming through our ports of entry, and only those who have documents, pardon me, showing that they are a national of the U.S., an immigrant lawfully admitted for permanent residence who's returning from a temporary visit abroad, an alien seeking admission as an immigrant in possession of a valid unexpired immigrant visa, an alien seeking admission as a non-immigrant in possession of a valid unexpired immigrant visa, a refugee, a returning asylee, or an alien who's been approved for parole under Section 212D5A. So, and it does not provide for legal representation. It merely requires the CBO, to the extent practicable, to allow those covered individuals to contact a family member, their boss, a counsel, by phone, or if possible in person, if they are held in lengthy detention. So the situation that you have described really is not part of this bill.
Thank you for that. I have spent a lot of time at the border in Texas, visited in Texas and in my home state of California. Certainly, there is a concern at the number of children that we are seeing. And I would simply urge my colleagues who continue to be, rightfully so, continue to be concerned about the number of children that we are seeing come to our southern border, that our concern really should be focused on the root cause of migration. And that is dealing with the Northern Triangle countries that are causing, a lot of the disruptions that we are seeing at our southern border. It is never acceptable to turn children away, to turn people away that do not wish to do us harm, that are simply asking for an opportunity to flee the horrible conditions and be able to live another day. During the Trump administration, I also visited the Northern Triangle and talked to people, shelters that had been funded in the last administration to prevent some of these kids that are coming north from coming north. We visited a center in Guatemala that housed teenage girls, and there were babies there. And those babies were a direct result of gang rapes in El Salvador. And those young women somehow found their way to this shelter, and they were being cared for there. They were given basic technical skills for them to be able to find a job, and so that they can support themselves and now their child. That was a good thing that we were doing. But all of those programs were the funding for those programs was zeroed out. So it is not surprising, and it should not be surprising to any of us, why we have now so many kids, very young kids in our southern border. So if we want to reduce that, we should work together to address the issues in the Northern Triangle. And with that, Mr. Chairman, I support this bill and would encourage my colleagues to support the bill, and I yield back.
Thank you. Dr. Burgess.
Thank you, Mr. Chairman. Fascinating discussion. Let me try to stay just on the bills before the subject of this Rules Committee hearing first, and then I'll have some general observations on the remainder of the other discussion that's been opened up. But Mr. McClintock, you said that there had not been a hearing on the No Ban Act and the Access to Counsel Act.
Yes, well, my understanding is that the bills may have been referenced in other hearings, but no, there were no hearings on these bills.
So
referencing a bill in a hearing doesn't make it a hearing.
If the gentleman would yield, that is consistent with the rule that we put in, I can read the thing to you, that on a bill or joint resolution to be considered pursuant to a special order of business reported by the Committee on Rules, a list of related committee and subcommittee hearings, and a designation of at least one committee or subcommittee hearing that was used to develop or consider such a bill or joint resolution. And according to the report, on February 11th, that's indeed what happened.
Well, Mr. Chairman, during the 116th Congress, we actually had hearings on these bills. That did not occur in the 117th
Yes,
Congress.
so as you know, in February 11th, according to the report, and Ms. Lofgren can respond to it if she wants, But what we have done to kind of differentiate ourselves from the way my friends behaved when they ran this house, like over 66 bills came to the Rules Committee that never had a hearing or markup period. So we put into the rules that that is what we expect when bills come to the Rules Committee. But I just wanted to point that out for the record.
Well, I can certainly agree that Republicans did not follow that rule as they should have, and we should have.
Correct.
You should now.
Mr.
Well,
Chairman?
reclaiming my
Oh, I'm
time just
sorry.
briefly.
Pardon.
The chairman is correct when he points out in the rules, but and of course you did give yourself an exception until April 1st, but we're well past that April 1st exception date, which is why I asked the question. I do think it's an important point that a piece of legislation that someone is proposing have the opportunity to be adequately evaluated by members of the committee under the Committee of Jurisdiction that's considering the bill. It doesn't sound like
it was.
Mr. McClintock has.
Well, it was. It is compliant with our rule. And Ms. Lofgren could maybe have something to add to that.
I'd be happy to yield to Ms. Lofgren if she
If
wants
the
to add
gentleman would
something.
yield, there was a
Yes, I'd be
hearing
happy to
on
do that.
there was a hearing on February 11th entitled the U.S. Immigration System, the Need for Reforms. It was not a single bill hearing. It was a broad hearing, but there were specific questions added into the record on the issue of access to counsel, as well as 212F, the so-called No Ban Act, and as well as other issues relating to the need for reform in the system. And I thank the gentleman for yielding. I hope that clarifies, and I yield back.
If I may, I believe, according to our staff, that was something that was added to the record after the hearing. And by that logic, every immigration bill taken up in the 117th Congress would now qualify as being heard because we had a subject hearing on general immigration reform.
And thank you for that clarification, Mr. McClintock. And the only reason I bring this up is I do remember the No Ban Act in the last Congress. I do remember us discussing it here at the Rules Committee. My recollection, however, was it was being brought in as a result of President Trump restricting flights from mainland China at the beginning of the coronavirus pandemic. And now we know with the benefit of perfect hindsight that that was actually probably a pretty good idea, maybe even one that should have been started a little bit earlier if the Chinese had actually been honest with us about what they were facing in their country in the city of Wuhan when this all started. But that's why I think it's important. The pandemic, of course, is well established. We're well beyond that point now. Donald Trump is no longer president, so I guess I fail to see what the rush is to get a bill like the No Ban Act through and voted on the floor so quickly. I'm not sure that members will understand exactly what they're voting for, because the whole tone of the discussion today is different from what it was when we considered this back in whatever it was, January of 2020, at least according to my recollection. So it would be great if we had the subcommittee, proper subcommittee, or I'm sorry, full committee vetting and the proper markup of this bill, where members of both parties would have had an opportunity to amend. And so I will find myself agreeing with Ranking Member McClintock that if this bill is heard on the floor, it should come up under an open rule to give all members an opportunity to be heard on this bill. Again, my recollection of when we heard this bill in the last Congress, the situation was just on the brink of people becoming aware of the pandemic, and they were angry that the president had issued this travel ban from mainland China. Again, we're past that point in the pandemic. President Trump is no longer the president, so it seems like we've got time to examine this in fulsome detail. So I guess I just don't understand what the urgency with bringing this bill forward to the House floor under such an expedited process. I'm missing something as to what the urgency for this bill is. And I'll be happy to listen to anyone's thoughts on why that urgency exists.
If I may, we did have a markup in the Judiciary Committee, and there were quite a few amendments that were debated extensively and voted upon. So I just wanted to clarify that for you, Mr. Burgess, and yield back.
Very well. On the access to counsel, Mr. McClintock, this is going to be a question for you. I mean, when we look at the bill where it goes through the discussion of a covered individual, well, there's a number of situations where you'd think access to counsel that in fact is that's a good idea. A national of the United States or an immigrant lawfully admitted for permanent residence who is returning from a temporary visit abroad. Those sound like, yes, access to counsel seems like rights guaranteed under the Constitution. When we reach number 5, where it just says a refugee, and we know that there are people who will claim refugee status who are then found later not to be able to substantiate that claim. So I guess, Mr. McClintock, my question to you is, what rights under the Constitution does someone have who enters or is attempting to enter and claiming asylee status? What rights do they have under the Constitution different from the rights of an American citizen who's returning from abroad?
Well, again, we're comparing apples and oranges here. My understanding is they have right to counsel the moment they set foot on American soil. But here's the difference. What they're doing at these inspection sites is not criminal in nature. What they are doing is assuring that everything that's brought into this country, including agricultural produce, as well as what's in the trunk of a car, all of that is legally allowed into the United States. It is not a criminal matter until they find something illegal. The moment that they find something illegal, well, then there is the right to counsel under current law. What this says is that at the beginning of the inspection, to determine that our import laws are being followed, they can immediately stop the process and demand either counsel or simply some other third party, possibly a co-conspirator. And if you can imagine applying that to the 17 million inspections that they conduct every year, you can see how, and the fact they're already overwhelmed and using antiquated facilities and short staff. You can see what the impact of this bill would be. But the moment a crime is alleged, well, then the right to counsel kicks in. But not in that secondary screening for a very important purpose. They're not screening for crime at that point. They're screening to be sure that materials that are brought into this country are being brought in according to law. And the impact of this is going to be overwhelming. Again, I also want to point out, this is not just giving a person the right to counsel, it's also giving them the right to call anybody else in they want and to gum up the process by doing that for extended periods of time.
As you describe it, it does sound unwieldy.
Let me tell you something else. There's one story that they told of finding very, very carefully hidden in a truck bed white powdered material in bags, very, very carefully hidden. Well, they took those bags out and they have some very sophisticated equipment that can determine what the compound was. Turned out to be cornstarch. Now, why in the world anybody would go to all of the trouble that they did to hide bags and bags of cornstarch, it's beyond me. They couldn't figure it out either. But it's not, as they said, it's not illegal to bring cornstarch into the country. That inspection, the individual was released, no crime occurred, no right to counsel therefore was incurred or invoked.
Well, I thank you for that clarification. Ms. Lofgren, did you want to add to what Mr. McClintock had said?
I'd be happy to do it. There's much that is inaccurate, unfortunately, with what the ranking member has just described. First, this does not give a right to counsel. This allows, where practical, a right to access, to make a phone call. It does not require delay in any way for the inspection of goods or vehicles. And it only applies to individuals who are documented. And by the way, refugees have documentation. They've been approved. They have a document approving their refugee status. It's not somebody coming to seek asylum. That would not be a person covered by this. And it only kicks in when they're in secondary inspection, at least more than an hour, where they could make a phone call. So it doesn't require stopping the inspections. It doesn't require a right to a lawyer. And in fact, you know, reasonable people can differ on whether they think this is a good aspect, but there's no right to counsel when you're entering the United States. There are issues, as we found in the Blaine, Washington situation, where American citizens were stopped and held for an extended period of time and refused entry to the United States because of their ethnicity. That is problematic, but even then, they did not have a right to counsel, government-sponsored counsel. I mean, they could, if they could have contacted somebody, they could have called their lawyer and gotten a habeas petition, because you can't legally stop an American citizen from coming back into the country. I mean, if they've done something wrong, you can prosecute them once they come back in, but that's not the rule that you can stop Americans from coming home. This is actually a very modest measure, and which is why it doesn't have a CBO score. It only allows what's practicable in terms of either a phone call or, if it's possible, allowing someone to actually come in. It's not prescriptive. It's flexible by design. It envisions that the DHS will set up the kind of process that's required. It permits but does not require lawyers or other interested parties to appear in person if that's a practical solution as decided by CBP, not by anybody else. And I'll just give you some examples of that we personally know. I mentioned the American citizens who were stopped wrongly, but there are people who come in with a visa. I'll tell you a case I actually know of someone who had a valid multiple entry H-1B visa, who was starting a software company. And the software company, as we all know, software's in the cloud now. It's not on little disks. And every time he would come in, CBP would say, well, where are the disks? And he said, there are no disks. It's in the cloud. I mean, if he could have had a call to a software executive to explain that really you don't have the disks, the CDs, the way you used to, that would have helped just clarify the facts. You've got people who are coming back who are researchers at medical institutions. For some reason, the CBP may have a doubt about that. If they could hear from the head of the research institute, it might be a piece of information useful to them in terms of making a decision. But in the end, the decision of whether to admit someone, unless it's a US citizen, belongs in the hands of the CBP. They make the determination. This does not alter that in any way.
Well, if I may just add, that turns the entire concept of customs on its head. If you can't that they don't detain people from coming into the United States. They detain contraband from coming into the United States. That's what these inspections are all about. If
No,
it
no, no,
turns
no, no.
out they
That's
suspect somebody
incorrect,
is
Tom.
they turn out that somebody is violating the law, then the right to counsel kicks in, because then you're dealing with a criminal.
That completely misunderstands what this bill does, with all due respect, Mr. McClintock. It has nothing to do with contraband. If somebody is found with contraband and arrested, then they have a right to counsel from a different constitutional point of view. This doesn't give a right to contraband to call their parent. I mean, it's a misreading of the bill.
No, quite the contrary. Why do you think they do these inspections? It is to prevent contraband from being brought in to the United States. That's the whole purpose of it.
Good.
That's why 17 million individuals a year are being waived into secondary inspections. And you can imagine the logistical problems that would occur if they can all invoke calls to legal counsel at that stage when no crime is being alleged. They're simply screening to be sure that everything is being brought into the country is being brought in according to law.
Well, it's the number you cited is not correct. And I think this is really a misunderstanding of the really quite modest reach of this bill. But I thank Mr. Burgess for your question.
Well, I'd just make the observation that some of this perhaps could have been settled if there'd been a specific hearing on the bill, but that's just me. There was a lot of discussion, and of course we are, the president described it as a crisis of the southern border the other day. I'll tell you, I was at the K. Bailey Hutchison Convention Center the day after it was announced that 2,400 teenage boys were going to be occupying the floor space there. And the commander of the Public Health Service, who I knew from previous visits to various ORR facilities, told me that they were in crisis management mode. I wouldn't think he would be in crisis management mode if he didn't have a crisis. So I do agree with the observations of Ranking Member Cole about the crisis on the southern border. I cannot tell you the number of times that I've been down there, previous administrations and now this administration. It's worse than I've ever seen it. And I don't know that people really understand the actual amount of human suffering that is occurring, because the perception now is that if you can get here, this administration is going to let you stay. It's going to let you in, going to let you stay. You'll be given a permiso, a notice to appear, which means you can work in the country for years and years before they finally get around to you. Cartels have successfully monetized this and are literally preying on people to separate them from their money for a trip for them or a family member up here and get them deposited on the other side, and in the case of Texas, the other side of the Rio Grande. And Mr. McClintock's observations are exactly consistent with the observations that I made a few weeks ago in traveling back to that area. I just can't stress how important it is for people to see for themselves. Now, a great deal of argument with the Obama administration, where President Obama would never, in spite of Governor Perry's invitations and entreaties to come and look at the problems on the border, President Obama would not do that. I do think it's important that President Biden do that. I think it's important that Vice President Harris do that. I actually don't find myself in disagreement with Chairman McGovern or Representative Torres about their observations about some of the things involving the root causes of migration. I especially agree with Ms. Torres. Do not give additional dollars to the governments of those countries from which these children are fleeing, because clearly those governments are not doing their jobs. They are not taking care of their people. And the last thing you want to do is to empower them with additional dollars from the United States taxpayer. The United States taxpayer is already taking care of their children in the ORR facilities at an enormous expense. that I don't even think we know at the present time how much we're spending on a daily rate for the care that we're providing these children. But by no means do not send additional dollars to the people who are in charge of running those countries until it can be demonstrated that they're actually doing their job for which they ran for office and for which they were elected, but clearly they are not. Why, if the object is to salvage children who are living in conditions that are not tolerable, why would you ask them to cross the Mexican desert on the top of a train to come to this country to get that? I mean, honestly, send a boat down to pick them up, but we're not doing that. And why would you, as a leader in a Central American country, why would you want to depopulate your country of your young people? That's probably one of the most pernicious things you can do for future stability. If you send all of your young people afield and ask them to send home remittances to support the government, this is nuts. This is no way that they should be running their affairs. And right now, we are enablers. We are helping them on that mission that really only leads to disaster. I'm just going to finish with one observation. I do think President Biden made a mistake, and he almost acknowledged it. He said, "I'm not saying don't come, just don't come right now." Well, look, Bill Clinton, when he ran against George H.W. Bush, made a big issue of the fact that George H.W. Bush was intercepting Haitians in rickety little boats and returning them to Haiti. And during one of the debates, Bill Clinton made it very clear that, boy, if he was president, there would not be this picking people up on the high seas, sending them to Guantanamo, and then repatriating them to Haiti. In fact, if he were president, it would be different. Then Clinton gets elected, and a week before he took office, a week before he took the oath of the office of the presidency, the week before his inauguration, he had to go on the Voice of America and directly address the people of Haiti, because he'd heard about the number of people who were building boats who were going to launch for the United States the minute after inauguration, and that there'd be significant loss of life on the high seas because these boats are not seaworthy. So Bill Clinton went on the airwaves through the Voice of America and told the Haitians, do not take to the high seas in these boats. There will be no change in United States policy with the Clinton administration. I think President Biden would do well to make a similar statement, not just don't come now, but let's reinstitute some of the things that were working that had reduced the effect of this irregular migration to the levels that Mr. McClintock has described in the early part of November, from the excesses that we see now. You talk about separating kids, dropping a child over a 14-foot wall, that's a separation. I don't care how else you care to describe it. Desperate circumstances notwithstanding, that is a separation. We saw on the front page of the Washington Times yesterday where the administration is suspended looking to establish paternity. Apparently the so-called fake family, if that's an actual term, supposedly that has really seen a resurgence. We have to get control of our southern border. It is a crisis, and the president needs to visit the area for himself. The vice president needs to visit the area for herself, since she's been tasked with this. But I do agree with Ms. Torres, do not send more money to those governments, because they are not doing the job for their people. Thank you, Mr. Chairman, for letting me rant. I'll yield back.
Thank you. And let me just say for the record that nobody is advocating sending more money to governments that cannot that mistreat their people. And the project that Ms. Torres was referring to in Guatemala that was housing these pregnant women, was a USAID program that did not go through the Guatemalan government. It went to an NGO, and Donald Trump cut the money. So,
Mr. Chairman, I visited the same facility in 2018. I tried to get Democrats to go with me. They declined.
Well-
But it was still up and functional
Well-
in September of 2018.
well, when we were there, the funding got cut. So that's the kind of funding we should be doing, and I hope the gentleman will support us in advocating for that. And let me thank Chairperson Lofgren for following regular order. We appreciate that, and that's what we would like we're hoping to the best of our ability that bills that will come to the Rules Committee, unlike when my friend was on the Friends Party was in charge, will come under regular order. I'm now happy to yield to Mr. Raskin.
Mr. Chairman, thank you very much. I just have a couple quick questions for Ms. Lofgren. First of all, some of our colleagues have described 1573 as a bill about the right to counsel, but it's not called the Right to Counsel Act, it's called the Access to Counsel Act. Is there any money that's put in here to pay for lawyers for people?
No, there's not. And as I'm sure the gentleman is aware, in the immigration system, even where there is a right to counsel, it's unpaid in the system. No one in immigration court is entitled to, or any other part of the immigration system is entitled to government paid counsel. And that's because it's civil law, not criminal law. As the gentleman knows, as a former law professor, if you are charged with a crime under the Constitution, you have a right to counsel. But this is civil. The entire code is civil, and so you have no right to paid counsel.
Okay, and just to further dispel some of the fog that's been created here, tell us exactly what the Access to Counsel Act does. When does it give you the opportunity to contact a lawyer?
If you are apparently lawfully presenting yourself for entry to the United States at a port of entry, you're a legal permanent resident, for example, or any of the other covered individuals that I read earlier, and you are pulled aside for a secondary inspection by the CBP. If after an hour you want to make a phone call, say to your family or your boss or a lawyer, and it is reasonably practicable in the judgment of the CBP that you can do that, you can do that. That's it.
All right, and I want to go to HR 1333, the No Ban Act. I understand that there's an effort to inflame the situation about the border, which the last administration had 4 years to do something about and basically did nothing about, other than waste billions of dollars on the president's fantasy border wall, which he said the Mexican government was going to pay for. But if we go back to the matter at hand, which is this legislation, I would think, Chair Lofgren, that this would actually be something that would unify everybody in Congress, because doesn't it just establish a principle that I think my colleagues endorse, which is that there should not be discrimination against people based on their religious free exercise? It seems like, my colleagues spent a lot of time talking about that, and you're just building that into the immigration laws, saying that there should not be discrimination based on religion any more than there's discrimination based on race or nationality or place of birth. Isn't that the heart of this bill?
Yes, the gentleman has it exactly right. The executive has broad authority to exclude individuals when he or she believes that their entry would undermine the security or public safety of the United States. This bill does not change that.
Okay, so essentially, if the president wants to exclude either a single alien or a class of aliens based on the security of the country, public safety, threat to democracy or human rights or international stability here. The president can still do that. It's just the president would not be able to say, we're going to exclude you because we don't like your religion. We don't like the religious faith you belong to. Is that right?
That is correct.
Well, why would anybody oppose that? What I don't understand is why this is controversial.
Well, I can't explain that, Mr. Raskin.
Okay, thank you, Mr. Chairman. I yield back, and thank you, Ms. Lofgren.
Thank you, Mr. Reschenthaler.
Thank you, Mr. Chairman. I appreciate it. Ms. Lofgren, I found it interesting that you used the term usurpation in your opening statement. I find nothing wrong with the word. It's a term of art legally and in the political science world. But, a few weeks ago, I used the term usurpation, and my liberal colleagues on this committee said that was a dangerous term. So I guess terms do matter. With that, I come to the question for you, Ranking Member McClintock. I understand that during markup HR 1573, Republicans offered an amendment to limit the term quote unquote interested party. And from my understanding, they did this to ensure that it does not apply to suspected criminals. Can you outline committee Republicans' concerns regarding the definition of interested party under HR 1573?
Well, I mean, it could be a co-conspirator, a smuggler, it could be anybody. Can
you elaborate on why this is
the biggest concern? The biggest concern is simply what this does to delay what is already an overwhelmed inspection process.
All right, and then there's been a lot of talk about the phone call. Could you see a situation where the phone call is used for nefarious purposes? For example, used if someone's smuggling drugs, used to call individuals on the other side of the border saying this mission's been compromised, et cetera. I mean, can you see ways where this call may not be used for its intended purpose?
Well, of course I can. I mean, including the fact they may have several other shipments running right behind them, that they can be warned, no, this doesn't work, they caught us.
Thanks. And Ranking Member McClintock, before I yield back to the chair, is there anything you would like to add that you have not been able to, that has not been elicited from questions?
Well, I'd like to respond to a couple of things were raised earlier. Starting with our need to address the strife in the countries from which these people are migrating. One of the Border Patrol officers told me a very interesting story. He confronted a mother who had brought a 5-year-old child on this terrible journey, and he said, "Why in the world would you submit your little boy to this kind of danger?" And she said, "Because we're trying to get away from the gangs and because I want him to get a good education." And the Border Patrol officer responded to her by saying, "You understand that the gangs you're trying to escape are already here. And your little boy is going to be placed in a school where he doesn't speak the language, where he doesn't fit in with the culture. He's going to be isolated. And the very people that he turns to for acceptance and protection are going to be the gangs that you're trying to escape." I think it's notable that the murder rate in Baltimore and Chicago has been reported to be higher than it is now in El Salvador. I've heard a lot about protecting children. Well, there's only one way to protect these children, and that is to convince those who are sending them not to send them because they will not be admitted. The only way to protect them is when they don't make the trip. This 2,000-mile trail of terror where reportedly 1/3 are being sexually molested and 2/3 are subjected to some form of violence. The policies that were in place were working. The humane thing to do is to prevent them from starting to make that trip in the first place. One teenage girl told one of our members that she was being bombarded with targeted ads on her Facebook page, convincing her to make the crossing. And there's one reason for that, because the cartels are right. If you're under 18 or claim you're under 18, you're automatically admitted to this country. If you have someone under the age of 7 in your group, you are very, very likely to be admitted to the country. And by the way, it doesn't come cheap. The cost the cartels charge for this often amounts to a full year of wages. Why would you commit that kind of money, often on credit, which means you're coming in here as indentured to the cartels? You want to talk about modern slavery? There it is. As long as they're being admitted, it's worth it for them. One of the Border Patrol officers said to me, the moment we start sending these children back to their homes, this will stop, because he said, you know, the cartels don't give refunds. The reason that this is happening is because we are allowing it to happen. The root cause is that our border is wide open. You know, one more thought. We visited an HHS site, and they were going to great length to tell us how they look for homes for these unaccompanied minors in the United States. But they don't lift a finger to get these children back to the homes that they came from in the first place. And that's why they're coming, because they can. It's not a matter of changing our rhetoric, it's a matter of changing our policies. We had control of the border last year, and children were not being submitted to all of these terrorists. We lost control because of specific policies of this administration, and now these children are making this 2,000-mile trail of terror trek to the United States and subjected to all of the horrors along the way.
Thank you, Ranking Member McClintock. I appreciate it. With that, Mr. Chairman, I yield back. Thank you.
Mr. Morelli.
I have no questions, Mr. Chairman. Thank you.
Thank you. Ms. Fishbach. I don't see, did I see Ms. Fishbach? No, okay. Mr. DeSagne. Anybody else have any questions?
Mr. Chairman, this is Deborah Ross. I did want to just speak briefly on the Access to Counsel Act.
Okay, go ahead.
Thank you, Mr. Chairman, and I'll be very brief, but I want to be very clear about this bill because it affects my district in the Research Triangle area very directly and not in the ways that this committee has talked about. And I spoke about it briefly in the Judiciary Committee. I consider the Access to Counsel Act a pro-business, pro-education, pro-research, and pro-technology bill. I have heard from businesses, employees, and students in my district who have legal papers who have been stopped at the border, and they have not been able to get the access to the help that they need to come in. I have heard from general counsels of companies in the Research Triangle area about these kinds of problems. This is such a serious issue that some of the foreign-born businessmen in my district told me it is one of the most important issues to them. It's humiliating for foreign workers and students who have lived, worked, and studied in the United States for years to be stopped and detained at the border and then denied the legal assistance that they need. My district is about welcoming these folks and celebrating what they have done to help the economy of North Carolina. The bill will cost the taxpayers nothing. It will just provide people the due process they need. And with that, Mr. Chairman, I yield back.
Thank you very much. Did anybody else have anything to add? Mr. Perlmutter, you all set? Or okay. So hearing no other members wish to ask any questions. Seeing none, that closes the hearing on HR 1333 and HR.
Mr. Chairman?
Yes.
Could I just quickly submit for the record a statement by Mr. Isa on HR 1573?
Without objection.
Thank you very much, Mr. Chairman.
So this closes the hearing on HR 1333 and HR 1573. I thank the witnesses and you are dismissed. We're now going back to hear amendments on HR 51. We have with us the Honorable H. Morgan Griffith, and the former distinguished chair of the Rules Committee, the Honorable Pete Sessions of Texas. And I don't see anybody else. So, Mr. Griffith, go ahead.
Thank you, sir. Thank you, Chairman McGovern and Ranking Member Cole, for allowing me the opportunity to discuss my amendment in the nature of a substitute that provides the appropriate alternative to DC statehood. I have constitutional questions, as do many, about the creation of a state from land that was ceded by another state for a particular purpose. The land that was ceded to form Washington, D.C. was donated with the particular purpose of creating a federal district for the common good. The two states, Virginia and Maryland, that donated the land to create the District of Columbia did not do so with the intent of creating a new state. And ceded by Virginia was not used for the Capitol's public buildings or other major federal installations. Congress passed a retrocession bill signed by the president in 1846. Though the Supreme Court has never adjudicated the merits of the case of Columbia's previous retrocession to the Commonwealth, it does seem to me that it is possible to rejoin donated lands to the original state from which they came, but not to create a completely new entity. That is why I have settled on retrocession as the most practical course of action. My solution to this constitutional conundrum finds its solution in the Constitution, in the plain language of Article 1 that requires no minimum size for the federal seat of government. Shrinking the seat of government and returning the rest of the land that's not used and was not previously given back to Virginia to Maryland for the purposes of representation offers DC residents a voice in the federal legislative branch, and it keeps faith with Maryland's original cessation of land or cession of land for DC and works within the bounds of the Constitution. My substitute amendment would fulfill the goal of ensuring that all DC residents are fully represented in Congress, but in a manner that does not go against the spirit of the Constitution. I have also taken great care to make the retrocession as smooth as possible and have drafted it in such a way as to make DC residents and government employees whole. It provides for the transfer of administrative functions from DC to Maryland, such as the criminal justice system and court systems and DC governmental property. This amendment, along with other things in it, merges the DC and Maryland National Guards units and makes DC retirees whole through continued retiree payments and college students whole through the continuation of tuition assistance. My amendment would efficiently unwind the District of Columbia's obligations in a manner that threads the needle between a constitutionally unsound statehood bid and the continuation of a status quo, which folks have complained about, and I think rightfully so, that they are taxed without representation. The founders' reasons for creating a separate seat of government still have merit. As then Attorney General Robert F. Kennedy noted back in the 60s, not the original founding, it was indispensably necessary to the independence of the very existence of the new federal government to have a seat of government which was not subject to the jurisdiction or control of any state. My bill respects this fact while also giving DC residents a voice in Congress. I appreciate your consideration. I'm happy to answer questions. There are lots of other questions that are out there that you may ask, but I will tell you, it's kind of like that old TV commercial where they asked about the spaghetti sauce, and they said, when they asked about it, the response always was, it's in there. We've got it covered. If you have a question, it's in there. And I'd be happy to answer any questions that the committee might have.
Well, we asked lots of questions in the previous panel, but in case anyone does, if you could stick around, that'd be great. I now want to yield to the distinguished gentleman from Texas, our former chair, Mr. Sessions.
Mr. Chairman.
Yes.
Mr. Chairman, thank you very much.
Oh, there you are. Okay. All right.
Mr. Chairman, thank you very much. Chairman Cole, thank you for allowing me to engage the Rules Committee today. I want to thank each of the Rules Committee members for their service, not only to this country, but their party and the hard work. As you know, I sat on this committee for 20 years and am aware of its complexities and the need for its process. Mr. Chairman, today I have an amendment to HR 51 offered by myself that talks about the enactment of law providing for participation in the election of the president and vice president. The act shall be made not to take effect until Congress deals with this issue of the 23rd Amendment. The 23rd Amendment, as you know, came as a result of, and was done very quickly as a result of, the need to make sure that people across the United States that we would be properly allowed itself not only to receive proper funding for its circumstances, but also to take care of the voting that would be necessary to allow them to vote in elections. Correspondingly, there were 3 electoral votes that were provided to the District of Columbia. The District of Columbia does have the voting that would be necessary, as the rest of the United States does, for the President of the United States with 3 electoral votes. We approached the committee in its committee, the Government Reform Committee, and said that we believe that there has to be discussion and an understanding about that, because otherwise it would be given these 3 electoral votes. It's not our amendment. Our proposal that's being made is one that's being made by the Democratic Party, and we believe it should be dealt with first, and so that is what I'm attempting to do here. Thank you, Mr. Chairman.
Thank you very much. I appreciate both of you being here. Mr. Cole, any questions?
Just very quickly, a couple of comments. And first, I just want to say for the record what a delight it is to see our former chairman back here and back in Congress. He led this committee with great distinction and served as the ranking member with a lot more distinction than the current ranking member has as well. So I just, it's always good to see my friend and have him back in the saddle. I will say, Mr. Chairman, I think both these amendments have considerable merit. Support them. To my friend, Mr. Griffin from Virginia, I supported similar legislation when our former colleague, also from Virginia, Mr. Davis, used to offer something. I think it's the most elegant and fairest solution, and that is, it satisfies the complaint that we hear legitimately about not having a voice in the Senate and not having a full vote in the House, and yet it does it, I think, consistent with the Constitution and consistent with the, if you really, I hope both your amendments are made in order, because if this really is about representation, and I take everybody at their word, but it's also political. It's also about 2 United States Senate seats as well. This would answer the representation question, which is the really important one in terms of individual folks. And then to my friend from Texas, taking care of this question of electoral votes before we actually move towards statehood rather than after seems to me to make eminent sense. So both very good amendments. I hope they're both made in order, Mr. Chairman, and without a yield back.
Thank you. Anybody on the Democratic side have any questions?
No, I just wanted to say thank you to the gentleman. I may not subscribe to your amendments, but I appreciate the thought that you put into them. I yield back.
Mr. Raskin?
Thank you, Mr. Chairman. I want to thank Mr. Griffith and my friend, Mr. Sessions, for coming and their thoughtful participation. I just want to say that the problem with the Griffith Amendment, from my perspective, is that the people of Washington, D.C. have already petitioned Congress for statehood. They're already on a path to enfranchising themselves that way, exercising their rights under the 9th Amendment to organize a new state. And similarly, the Maryland General Assembly has not asked for retrocession. And so his amendment would be an outside imposition both on the people of Washington, D.C., who've asked for statehood, and on the people of Maryland who've not asked for return of the lands. So, I mean, other than that, it sounds like a great proposal, but nobody seems to be asking for it. And, as for, my friend, Mr. Sessions, on the 23rd Amendment, I think it would be unfortunate if the rights of more than 700,000 Americans get hung up on this issue. Again, Congresswoman Norton's bill repeals the Electoral College statute at the exact same time that the new state is admitted. So there's no danger 3 electors could be activated because the activating statute is repealed in the terms of the bill. And then, of course, we will proceed to have a 1,000% to 0 repeal of the 23rd Amendment. The problem with doing it the other way, and I'm certainly not imputing this motive to Mr. Sessions or anybody else who's speaking for this as a solution, but the problem with it is that if you say, well, we need to repeal the 23rd Amendment first, at that point, anybody who opposes DC statehood can just say, let's not repeal the 23rd Amendment. And then it also creates the moral hazard that it could be repealed and then it's still blockaded, which means the people of DC have now lost political ground. At least right now, they get to participate in presidential elections. They don't get the heart of representation in the federal system, which is representation in Congress with voting members. But doing it in the direction that's suggested by this amendment, I think, turns it upside down. It basically says we're going to give the states, for the very first time in American history, a veto power over admission of a state. And then even if they were to act in good faith, say, okay, let's repeal it, at that point, there's no guarantee that people in DC will get their rights to participate in presidential or congressional elections through statehood admission.
Would my gentleman from, my good friend from Maryland yield just so I can make a kind of related point?
Yes.
Thank you very much. You had mentioned Oklahoma, and it got earlier in your remarks, got me thinking about the original conditions for my state coming in. And it does suggest to me, at least, and I'm certainly, my friends are much more knowledgeable than I am in these areas, but originally Oklahoma wanted actually to come in as 2 states. There was a movement in eastern Oklahoma to have what was called the state of Sequoia, which would be primarily where the majority, though certainly not all of the native population was, and the original 5 great tribes that had been moved from the southeast wanted to be an individual state, which would have been democratic. The state eventually was anyway. Western Oklahoma, which probably would have come in as a Republican state, was fine with that. But Congress actually, and particularly President Roosevelt, decided, number one, I don't think he wanted to risk 4 Democratic senators. But he also just didn't think the state made economic sense without being shoved together. So just because you petition to be a state doesn't mean you can't come in some other way. It doesn't mean Congress can't use its discretionary power to decide, well, we'll let you do this, but this is the way that it makes sense in the union. So let's say that just a little piece of history, and it may or may not be relevant to the discussion. But anyway, thank my friend for yielding. Yield back.
Yeah, well, thank you, Mr. Cole. I mean, that's very illuminating. And the history of each of our states' admission or inclusion from the beginning in the original 13 is fascinating. And when I went back to look at this, hearing constitutional and political objections to Washington, D.C., what I recognized was that all the same kinds of arguments were made at each step along the way. Everybody knew that Hawaii and Alaska could not be admitted as states because they were not contiguous. Everybody knew that Texas, that was totally unconstitutional because it had been its own republic and there was no provision in the Constitution for admitting a foreign government and so on. And of course, there are the improvisation of new tests all the time, a lot about poverty and wealth and religion. It was said, of course, Utah could not be a state because a majority of the people were Mormon and they embraced polygamy, and it got wrapped up in the politics of plural marriage and all that stuff. I mean, that is the history of our country. So there's nothing too novel or strange about this, but I would say this in response to your final point. It's true that there's nothing that makes us recognize the new states, but in the final analysis, even after years or decades of struggle, Congress will end up saying, you have the right to your equality too, as a community. That has been the trajectory of our country. That's a beautiful thing, because ultimately we do believe in democracy. I yield back, Mr. Chairman.
Anybody on the Republican side have any questions?
Mr. Chairman?
Who's that? Mr. Sessions.
Yes, sir, and I apologize. I recognize I am not a member of the committee, and yet because we're not in the same room, it's a little bit different. First of all, let me say this: both Mr. Cole and and Jamie, Mr. Raskin, make valid arguments on either side of this. What I would say to you is, I think this is a little bit different because it was originally ratified by the states. The states have a say in that ratification. They did. Mr. Raskin wants to argue, well, theoretically, anybody could stop it. Well, it's not a unanimous decision. It's not required of every state. But I would argue from a constitutional perspective, in the balance of power with the federalism that we have, we've given the states this authority to have an opinion about that. And that opinion is being taken away from them. And I believe that that is fundamentally flawed. We have not been through these exercises. When you go to prohibition and you look at prohibition and how quickly or the process that went on, it still went through a ratification afterwards. And I do admit that. I've looked at that, but that was never ratified necessarily the same way, the same process. So I would say to you, I thank you for allowing us. And the last part is, Mr. Chairman, as you recognize, Mr. Cole does also, the intent of what this Congress does in dealing with this has an overwhelming sense when it goes to any court of the intent. And I am saying to you, in my opinion, the intent of the states is a guiding measure, and they should be confronted first on that. Thank you, Mr. Chairman.
Any other questions of the panel? Seeing none, this closes the hearing on HR 51. I thank the witnesses. You're dismissed. At this time, the chair will entertain a motion from the distinguished gentleman from Maryland, Mr. Raskin.
Mr. Chairman, thank you very much. I move the committee grant HR 51, the Washington, D.C. Admission Act, a closed rule. The rule provides for an hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Reform or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Oversight and Reform, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit. The rule provides for consideration of HR 1573, the Access to Counsel Act of 2021, under a closed rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on the Judiciary, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit. The rule provides for consideration of HR 1333, the No Ban Act, under a closed rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on the Judiciary, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit. The rule provides that House Resolution 316 is hereby adopted. The rule provides that House Resolution 188, agreed to March 8th, 2021, is amended in Section 11 by striking April 22nd, 2021, and inserting May 20, 2021. In Section 16 by striking calendar day of April 22nd, 2021, and inserting legislative day of May 20, 2021. And in Section 17 by striking April 22nd, 2021, and inserting May 20, 2021. The rule provides that at any time through the legislative day of Thursday, April 22nd, 2021, the Speaker may entertain motions offered by the Majority Leader or a designee that the House suspend the rules with respect to multiple measures that were the object of motions to suspend the rules on the legislative days of April 19 or 20, 2021, and on which the yeas and nays were ordered and further proceedings postponed. The chair shall put the question on any such motion without debate or intervening motion in the ordering of the yeas and nays on postponed motions to suspend the rules with respect to such measures is vacated. The rule provides that House Concurrent Resolution 30 is hereby adopted. Finally, the rule provides that for purposes of the joint session to receive the President of the United States on April 28, 2021, former members, delegates, and resident commissioners shall not be admitted to the hall of the House or rooms leading thereto.
You heard the motion of the gentleman from Maryland. Is there any amendment or discussion? Mr. Cole?
Thank you very much, Mr. Chairman. Before I offer my amendment, let me make a quick personal note. I had noticed coming into the rules office that you'd set up a tribute to our late colleague, Mr. Hastings. That those of you that hadn't had a chance to see it should come over and take a look. Brought back a lot of great memories. I really want to thank anybody on the staff that had anything to do with it. It was just very, very fitting. So thank you very much.
We all miss him.
Yeah, boy, that is for sure. Mr. Chairman, let me first offer my I'm sure well-expected open rule and make quickly a point. Look, on the DC statehood bill in particular, there really is the opportunity for bipartisanship, or at least a bipartisan expression of the underlying principle that everybody purports on the Democratic side to want this to be about. That is that people should have representation in the United States Senate, the United States House. That's really what Mr. Griffin's bill does. And so if this is genuinely about that, we may disagree. Mr. Raskin's made a case to the other point of view fairly, I think. Then both parties have an opportunity to express that. If we leave it like it is, it's going to be a strict partisan vote. It's going to get the United States Senate that way. And I don't think that will bode well for its ultimate prospects, but we'll see. Regardless, I think an open rule would be the appropriate thing. So I offer that as an amendment to the rule.
You heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
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 Opposed, no.
No.
No. The chair, the noes have it.
Mr. Chair, I'd like a roll call on that, please.
Roll call has been requested. Clerk will call the roll.
Mrs. Torres?
No.
Mrs. Torres? No. Mr. Perlmutter?
No.
Yeah. Mr. Perlmutter? No. Mr. Raskin?
No.
Mr. Raskin? No. Ms. Scanlon? Mr. Morelli?
Morelli's no.
Mr. Morelli? No. Mr. DeSaulnier?
DeSaulnier, no.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Mr. Reschenthaler?
Aye.
Mr. Reschenthaler? Aye. Mrs. Fishbach?
Yes.
Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk will report the total.
7 yeas, 3 nays.
Amendment is not agreed to. Further amendments? Nope. No further amendments? Okay.
Okay, sounds good.
So if there's no any other amendments?
Mr. Chairman, Mr. Chairman, I do have an amendment, excuse me.
Okay, all right. Mr.
Reschenthaler.
Reschenthaler, go ahead.
Thanks, Mr. Chairman. Mr. Chairman, I have an amendment to the rule to make an order, amendment number 5 to HR 51, offered by Mr. Keller of Pennsylvania. This amendment requires that Statehood Transition Commission established under Section 402 of the bill to create a report showing what expenses the new state will need to assume responsibility for on the first day of admission into the union, and prevents subsidization of the new state by federal taxpayers. Mr. Chairman, currently DC residents have access to many special programs and services funded by the federal government, but the bill before us today lacks clarity on what the federal government will continue funding before granting DC statehood. Likewise, neither the majority or the DC government have indicated how the new state will exist without continued financial assistance from the nation's taxpayers. This amendment would require that the Statehood Transition Commission established by HR 51 will actually do something before statehood is actually granted. With that, Mr. Chairman, I urge the adoption of my motion. I yield back my time.
Before I take a vote on that, can I ask the clerk to give me the vote count on the previous amendment?
Apologies for that. It is 3 yeas and 7 nays.
Okay, and so the amendment is not agreed to. Now, you heard the gentleman from Pennsylvania. Any discussion? Hearing none, the vote is on the Rushenthaler amendment. All those in favor say aye.
Aye.
Opposed, no.
No.
Can you hear the noes have it?
Mr. Chairman, I would ask for a recorded vote.
A recorded vote has been requested. Clerk will call the roll.
Mrs. Torres?
No.
Mrs. Torres? No. Mr. Perlmutter?
No.
Mr. Perlmutter? No. Mr. Raskin?
No.
Mr. Raskin? No. Ms. Scanlon? Mr. Morelli?
Morelli's no. No.
Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Mr. Reschenthaler?
Aye.
Mr. Reschenthaler? Aye. Mrs. Fishbach?
Aye.
Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk report the total.
For what?
3 yeas, 7 nays.
And the amendment is not agreed to. Further amendments?
Mr. Chairman.
I think.
Oh, excuse me.
Okay, go ahead.
Well, I'll yield, Mr. Chairman, if Mr. Raskin has an amendment.
He doesn't. I don't think. Do you,
Okay,
Mr. Raskin?
I heard of. I didn't think he did, but out of extreme deference, I wanted to yield. Thank you, Mr. Thank you, Mr. Chairman. Mr. Chairman, I have an amendment to the rule to make an order amendment number 1 to HR 51 offered by Mr. Comer of Tennessee. The Comer amendment provides that HR 51 will only take effect upon repeal of the 23rd Amendment. I want to thank Ranking Member Comer for his compelling testimony today and reiterate that if this majority were acting responsibly, they would have acted to repeal the 23rd Amendment before moving to enact this bill. This amendment clearly states, and I quote, "The district constituting the seat of government of the United States shall appoint in such manner as Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than no more than the least populous state," end quote. Mr. Chairman, if the 23rd Amendment is not repealed, 3 electoral votes will be granted to those remaining in the district, presumably the president and his or her family, maybe a few others. So basically, theoretically, Hunter Biden could actually get control 1 electoral vote if we don't appeal this. And Mr. Chairman, I must say that even Delegate Norton said that the 23rd Amendment would be easily repealed. If it's so easy, let's repeal this before moving forward. With that, Mr. Chairman, I urge my colleagues to support this motion, and I yield back.
Thank you very much. I recommend a no. You heard the gentleman's amendment. All those in favor say aye.
Aye.
All those opposed say no.
No.
Opinion of the chair, the noes have it.
Mr. Chairman, I'd ask for the yeas and nays.
The yeas and nays have been requested. The clerk will call the roll.
Mrs. Torres?
No.
Mrs. Torres? No. Mr. Perlmutter?
No.
Mr. Perlmutter? No. Mr. Raskin? Mr. Raskin?
No.
Mr. Raskin? No. Ms. Scanlon? Mr. Morelli?
Morelli's no.
Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess? Mr. Reschenthaler?
Aye.
Mr. Reschenthaler? Aye. Mrs. Fishbach?
Aye.
Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk report the total.
3 yeas, 7 nays.
Mr.
Mr. Chairman.
Chairman,
Mr. Chairman.
Mr. Burgess is trying to check in right now.
How is Dr. Burgess recorded?
Dr. Burgess is not recorded.
Okay, we'll give him a chance to check in here.
You got it?
Is he in here?
Hang on just a second.
Yeah.
You want to come down here and give a
No, I got
thumbs
it
up?
now.
No, he's got
Okay.
it.
How's Dr. Burgess recorded?
Mr. Burgess is not recorded.
Votes aye.
No. Okay, I'm
Mr.
sorry.
Burgess, aye.
Clerk will report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments.
Mr. Chair, I have an amendment.
Ms. Fishbach.
Mrs. Fishbach.
Yeah, okay, there you go. All right. You can proceed.
Thank you. Mr. Chair, I have an amendment to the rule to make an order amendment number 1 to HR 1573 offered by Mr. Ice of California. This amendment delays effectuation until the Secretary of Homeland Security certifies the bill will not cause a substantial negative impact to CBP's ability to facilitate lawful trade and travel into the U.S. Mr. Chair, the language of the amendment ensures that the Secretary cannot evade compliance by citing any negative impact, but must identify a substantial negative impact. This amendment will help ensure that the bill before us today does not impede the efficient operation of our ports of entry if its inaction would cause a significant disruption to lawful trade and travel. For this reason, I urge adoption of my motion and I yield back.
Heard the gentlewoman's amendment. Any discussion? If not, the vote is on the Fishbach amendment. All those in favor say aye.
Aye.
Opposed, no. No.
No.
Chair, the noes have it.
Mr. Chair, I call for the yeas and nays.
Yeas and nays have been requested. Clerk will call the roll.
Mrs. Torres. Mr. Perlmutter.
No.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Ms. Scanlon.
I'm not gonna.
Mr. Morelli. Mr. Morelli.
Mr. Morelli. Someone throw something at the screen. Morelli.
Yeah, we've already.
Come back to him.
I don't want to now.
Mr. DeSaulnier.
Myself in line at the end.
Mr. DeSaulnier, no. Ms. Ross.
No.
Ms. Ross, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Burgess.
Votes aye.
Mr. Burgess, aye. Mr. Reschenthaler.
Aye.
Mr. Reschenthaler, aye. Mrs. Fishbach.
Aye.
Mrs. Fishbach, aye. Mr. Chairman.
Mr. Chairman,
No.
Mr. Chairman, no.
And how is Ms. Torres recorded?
Mrs. Torres is not recorded.
yeah, I'm sorry. Mr. Chair, how am I recorded on that vote?
Hold 1 second. Mrs.
Torres is no.
All right.
Mrs. Torres, no.
And how's Mr. Morelli recorded?
Mr. Morelli is not recorded.
I'd like to be in the negative.
Okay.
Mr. Morelli, no.
Okay. All right. Okay, we got everybody. Okay, so clerk report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments? Hearing none, at this time, the chair will so this time the vote is on the motion from the gentleman from Maryland, Mr. Raskin. All those in favor say aye.
Aye.
All those opposed, no.
No.
Mr. Chair, the ayes have it.
Mr. Chairman, on that, I would request a recorded vote.
Recorded vote has been requested. Clerk will call the roll.
Mrs. Torres.
Aye.
Mrs. Torres, aye. Mr. Perlmutter.
Aye.
Mr.
Aye.
Mr. Raskin, aye. Ms. Scanlon. Mr. Morelli.
Morelli is aye.
Mr. Morelli, aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier, aye. Ms. Ross.
Aye.
Ms. Ross, aye. Mr. Cole.
No.
Mr. Cole, no. Mr. Burgess.
Votes no.
Mr. Burgess, no. Mr. Reschenthaler.
No.
Mr. Reschenthaler, no. Mrs. Fishbach.
No.
Mrs. Fishbach, no. Mr. Chairman.
Yes, aye.
Mr. Chairman, aye.
Clerk report the total.
7 yeas, 4 nays.
The motion is agreed to, and Mr. Raskin will handle it for the majority.
And Mr. Reschenthaler will handle it for the Republicans, Mr. Chairman.
Okay, all right, then that's the end of the day. Okay, beautiful. All right, everybody, thank you very much. The Rules Committee is adjourned.